Bis Yes. Application and order for was mentioned next week, and also other ones. Column. What? No, not this one.
I have stopped covered telephone, my lord. I have informed the Lord Advocate representing the expedition. Dr. Bhaskar Chandra Kumar. My lord, he hired expedition, my lord, along with 10-15 expedition. One of the expeditions approached to my lord, my client, we are the respondents. That
What do you want now?
He did not find anything while he is present in court. He came from the Jharkhand.
What should you do?
My lord, I don't know, my lord. Item number 85.
Please don't mention unnecessarily. When the matter is called on,
Since he's present, my lord, that is why I mentioned it.
I did not invite him. Call on the list. No other mention. No other mention.
But
Yes.
for modification of an after violence.
Not with you. Yes. Sorry.
And today is the last day for payments.
I didn't for one for just.
I am for that.
My lord.
Today is the last day for payment of the client charges. Unless it is, I have.
Go to deliver.
In the circumstances, this court finds no reason to interfere with the impugned order. It said if impugned order is affirmed, thereby the instant appeal being FMA 656 of 2023 stands dismissed. Accordingly, can 5 of 2024 is disposed of.
Follow this. Next.
Item number 2.
Yes. Non-prosecutor. Learned counsel for the appellant submits that the appellant does not want to proceed further with the matter. You are the review applicant. Learned counsel for the appellant stroke review applicant submits that the review applicant does not want to proceed further with the matter, which are accordingly RBW 277 of 2025 along with CAN 1 of 2025 are dismissed as withdrawn without any orders to court. Written instructions is that in that regard, filed by learned counsel today be kept on. Yes.
Item number 3 with 4.
Yes. Yes, please. You wanted to cite admin such a.
Another thing, my lord. Something, my lord, I want to point out for subject matter.
Yes.
The scheme of the 1948 Act was like Miller section 17 of the Act 1, 1890. Now, why I am saying? Because you will kindly see first Miller in 1948. And my lord was certain enough to
Land acquisition activity. Thank you.
Yes. The last question, my lord, is observation, Mr. Shashupta. Where is the provisions from which onwards the authority will give it 2013 Act is not applicable? After on which stage the authority will take the property or initiate the property?
Yes.
But first of all, my lord, kindly see my humble submission will be, my lord, the West Bengal, that is the Land Acquisition Act 1948 Act 2, is, my lord, an emergency provisions and is like, my lord, entire material to section 17 of Act 1. This is my humble submission. Why I am saying, kindly come to first, my lord, Land Acquisition Act, West Bengal Land Acquisition Act in 1940. My lord, kindly come to first, my lord, 3. section 3 power to requisition. Malad both that Malad did not write later read Malad. Section 3 power to requisition. That Malad requisition position was taken, and Malad if now on section 4. Section 4 says that where the land has been requisitioned under section 3, the state government may use or deal with such land that any of the purposes referred to subsection 1 of section as may appear to be. State government may acquire any land requisition under section 3 by publishing notice in the official that such land is required for public purpose referred to subsection 1 of section 3. Where a notice as aforesaid is published in the official gazette, the requisition land stand foreign from the beginning of the day on which the notice is properly vested, absolutely in the state of the from all incumbents, and the period of requisition shall stand salient. So, if the authority satisfied, yes, 41 is required, then my lord, if as soon as the 41 was invoked at the material point of time when the act was alive, the land is vested. Land was vested to the state government. Now, my lord, kindly consider দুটোই বললাম স্টেট গভর্নমেন্ট রিফর্ম অল আমি সব করতে একটা সেকশন 2 মানে আর অলরেডি নেই মানে where the notice as opposed is published officials again the requisition land sale on from the beginning of the day when notice so published best absolutely in the now my lord kindly see first my lord then my lord 6 section 6 5a my lord I am not reading because my lord was likewise my lord we provisions equal to the Act 1, 89. Section 6 release. Also, it is there in the Act 1. It is in the it is included in the provision of Act 1 because if the land is not required, if after being satisfied the land is not required, then it can be requisitioned. Likewise, Section 3. Well, I am not reading. Well, now, kindly see this say Section 7 compensation. Wherever any land is acquired under section 4. So 4 includes 1A, subsection 1, subsection 2. Then, my lord, the collector in the manner in accordance with provisions set out in 1A of specified sections 23 of the Land Action 1894. And as there may be, as far as there may be applicable. Provided that market value referred to first section subsection 23 of SAL in respect of land acquired under this act be deemed to the market value on the land of the date of the publication of the notice referred to in subsection 1 of section. So, my lord, this clear 7A deals with the compensation. And my lord, Land Acquisition Act, now my lord, subsection 2A, when the compensation has been determined under subsection 1, collectors shall make an award in accordance with principles set out in the section 11 of the Land Acquisition Act. And the amount of referred to as subsection 1, 1A, 2, or section 3 shall be also be included. So it is clear how the which stage the authority will proceed after issuance of invocation of section 418. Now, my lord, kindly see
The section 5 notice also has to be given.
no 5 is not required. 5A is not required.
5A is exclusion of noise.
Yes.
Why is
5 is not required. Notice to persons interest after notice.
For the purpose of
notice 5 is already discovered.
Yes.
Section 4 notice was issued. Yes.
So
It is
after
an administration.
acquisition, it has to proceed from section 5 stage.
Section 5 state. Yes. Now, my lord, compensation part is to be governed by the provisions included in the Land Acquisition Act. And from section 11, that award has to be published. Now, my lord, kindly consider the amount, my lord, sometimes, my lord, the authority didn't know, my lord, how the interest to be calculated. Here also there, provided that, my lord, kindly come to subsection 2 last part A, provided that, I have already read subsection 2A, that 11A award in accordance with the principles that I have already read. Then, my lord, kindly provided that interest at the rate of 9%, my lord,
This is what are you reading?
my lord, subsection 2A of section 7,
Yes, provided
when
that,
complete provided.
yes,
First 11,
9%.
yes, yes, yes. When the interest of the 9% per annum on the amount of completion on the award from the date of publication notice under section 1A or 1A of section 4 until payment shall be made included in the amount payable under the award. Provided that the such completion any part is not paid or request within a period of 1 year from the date of publication of the notice of subsequent interest at the rate of 15% per annum shall be payable from the date of expiry of a said period of 1 year on the amount of commission on part of which has not been paid or deposited from before the date of expiry. Such awards shall be filed in the character of which A manner and shall accept as well the final and conclusive evidence as between the collector and the person interested as well as they appear before the collector and not the true area of the value of the land and the approximate of the compensation among the person interested. Collector shall give in the prescribed manner immediately notice of his award to such person interested as well as are not present personally or by the representative when the award is made. Upon an award being made, manner kindly see, upon an award being made under subsection clause A, the collector shall proceed to make payment in accordance with the provision of section 31 to 33 land action as far as revealed. So everything has been well incorporated and it will be governed by the provisions incorporated in the Act 1. Where land is requisition returns shall be paid to any person calling respect or requisition, everything. Well, I am skipping over, principle to be followed, I am skipping over. And if there is a disagreement between the collector and person interested, compensation shall be determined by the court in reference made by the collector under subsection, so subclause 3 of section 1 of section 8. My lord, now, my lord, kindly, this is more important ceremony. That is included in the year 1996. That by way of amendment, by dint of amendment 1996. This is the, my lord, bone of contention, and my lord, which I am raising that the judgment judgment, my lord, is totally pari. And my lord, on that, my lord made an observation, Mr. Shengupta, whether I be sitting in the judicial bench, whether we can stay there. My lord, now, my lord, 7A, my lord, I am reading. Collector shall make an award. My lord, on the last occasion, my lord made an observation. Mr. I made a submission on the basis of my lord made an observation. Mr. Shengupta, the notice will be asked. But vesting, there is no such thing like vesting and other provisions. Because vesting was one of the part, then my lord, the other part has to be taken into account, 80%. My lord, I will show that. There is no such thing in section 7A. Because the legislative amendment that was my lord done in the year 1996.
But if the notice lapses, Mr. Shengupta, what will be the effect? Because vesting is by virtue of the notice.
In a way, vesting will go. But my lord, the vested means that is an acquired. This is the already state has become the owner of the land. That means specifically you has to be specified in that because other provision has to be amended. Because vesting, the consequence after vesting, these are things has to be done, and the authority has done this. And I will show that. And here only seen that in a case where the notice has been published more than 2 years, an award shall be made in 1 year from the date of consequence of that. And if such award is not made, first paragraph I am saying, is not within a period of the said notice shall lapse. And provided that and the 1 year that the was given is stayed by an order and something like that, that will be excluded. That is there normally, as the law says. Now, kindly see. Reference to court, now, kindly see 8B. 8B, it was amended in the year 1974. There is no mentioning in the 1996 also if that means whatever amount you have paid that has to be released immediately. There is nothing in the section 7A because before vesting, my lord, you have to make payment of 80%. Likewise, my lord, 17(1). Right? Let's paragraph it, my lord, in a sense, my lord. Kindly consider 8B on account of payment in advance. What 8B? It is Incorporated, my lord, it is amended in the year 1974. My lord, got it, my lord can get it, my lord, after it is in the year 1974 because the Bengal law is and my lord, I do not know whether it is there or not. It is in the year 1974. It amendment. 8B, 8 capital. My lord, kindly see where the state government requisition any land under subsection 1 of section 3 and decides to acquire it under subsection 1A4, it may, notwithstanding, well, this is very bad. Notwithstanding anything contained in the foregoing provision of the act, that includes 7A. Immediately after taking possession of the judicial act, make an estimate of the likely to be determined as subsection 7. Malad answer, Malad have already read compensation to additional and compensation. 80% means relating to compensation. And make summary inquiry about the person interest owner, and after taking such security as it may think fit will make to such person by advance on account of payment was compensation up to 80% of the procedure, provided nothing in such shall affect the liability of the person who received compensation in advance indicated above to pay the same to the person lawfully entitled there. It is not relevant because if the person is lawfully not entitled, that amount can be taken as or my submission, my lord, kindly see first, my lord, legislative, each word has to be taken specifically. My submission would be vesting is something else. And 7A, when it was amended in the year 1996, my lord, only the notice will go. But others didn't, the 7A amendment portion didn't touch 8B.
What will be the effect of that? Notice goes.
Yes, notice goes, my lord. I have to be candid before my lord. If the notice goes, my lord, vesting goes. Because notice is part of section 4.1A is clearly read that
Recognition of vesting.
Section 4.1A.
Then the vesting should also go.
If the notice goes, actually, my lord, but my lord, at the time, legislative, my lord, it is my lord, legislature on his own, my lord, kindly consider the fact that 8B it was not touched. So notwithstanding, it may notwithstanding anything on foregoing position, immediately taking position, you have to do this. So 80% remains compensation.
Yes.
So 80% compensation were being paid. And even if it is not paid, and I am opening another form, then I will make that submission. Well, now my whole intention or the submission would be, my lord, subject to my second kind approval, that the scheme of the Act 2 is parametric to section 17 of Act 1. So let us see, my lord, 17.1. Because 17.1, kindly see. Now I will come the letter amendment. Number 17, manner special powers in case of emergency. Already I have made submission that that is 2, that is 1948 Act, which was a temporary act. It is in nature, my lord, the provisions analogous to the 17.1 of Act 1, because it is an emergency provision. Because the section 4 says that if the authority are being satisfied that it is to be acquired for the public purpose, then they can invoke. If they do not invoke, then, my lord, there is no question of acquisition of land in question. Likewise, 17.1, because the wording is same, verbatim, I should say that. But kindly see 17.1, in case of urgency, my lord, skipping over just the appropriate with the previous subclause 2, my lord, subsection 2 with the previous last 3 lines, with the previous sanction of the enter upon takes possession of such land which shall thereupon vest absolutely on free from all income. And my lord, here, my lord, there kindly see here 80% is there the 3A. 3 capital A, my lord. That before taking possession of land, my lord got it? That subsection 1, collector shall do mention that tender payment of 80% of the compensation for such land as estate. Now, my lord, kindly consider why I am showing this, my lord. First submission, my lord, this parameter to section 71, the scheme of the Act, the 1948, if section 418 was being invoked at the material point of time. My lord, now, my lord, kindly come to 11. This is very material. It is also relevant for the purpose 11 of the land act. First, my lord, 11 of the land act. My lord, that is inquiry and award by the collector. It starts from my lord 11 section inquiry and now my lord collector my lord has to pass an award. Respect interest claiming compensation shall make an award under his hand. True value of the land compensation within only service shall be and my lord in another case my lord wanted to actually my lord intention was in another matter that there is nothing in the made an observation. There is nothing in the award how the award to be framed. There is nothing in the provision, and the analysis is absolutely right because I was sitting there. Only matter there is no such ballots. The prescribed thing but which the award has been was only 11, and from 13B that is there only. Now make an award under these things inquiry. Now my lord kindly comes to 11A. That is very bad. 11A period within which award shall be made. Well, two things are to be taken into consideration. One is vesting goals. Even if for assuming but not admitting the vesting goals. And another thing, further, that entire land acquisition proceedings to plans. There are two different things. Here, 11A, that is amended by amendment in the Act 1, and 9C and 9CD I also show, State Bengal Amendment, I will also show. First matter 11, collector shall make an award under section 11 within a period of 2 years from the date of public declaration. If no award is made within the entire proceeding for the acquisition shall lapse. So, my lord, two things. If the award is not made within a specified period, the entire acquisition proceedings could lapse. Because I will show the development of law regarding this. Well, now, my lord, providing case has been published before the within a period of 2 years. I am skipping over in computing 2 years. These are all. Now, my lord, kindly see in the state amendment, 9C and 9CB also amended. They are the same thing. The award shall be made within a period of 2 years from the date of issue of publication and other thing is verbal. That is entire administrative process. Now, my lord, kindly consider first of all, my lord, I will show from the latest the development of law.
But we said, why aren't you relying on section 9CB?
9CB. Oh, 9CB and 9CA that has been regarding, they will certainly make submissions that within, if it is not medieval for argument's sake, award is not made within a period of 2 years or something like that. That is the amendment. 11 that is incorporated in 9C and 9CB. If it is not made, if the award is not made within a period of statutory period, then entire acquisition proceedings to lapse. They will certainly
no, but section 9CB of the West Bengal Amendment in the LA Act is in your favor. The second.
Yes, but I will show entire thing.
No, but
why I am showing? Yes,
9CB.
Yes.
Because we have to read 9CB along with that.
And 9C also I will read. 90, and after that, why I
3A is different. Here, section 3A is only requisition has been made.
yes.
3B is where requisition and notice of acquisition has been made. So let us come to 9CB once.
They can
If that.
why I am showing, because they can make a submission that 9CB also, even if it is not made, then the statutory period award is not made within a statutory period, and then they will take this point. So I will show that it is not applicable. Because of 9CB,
9CB second proviso says that the lapse will be only in respect of still an award can be made.
yes,
You please come to 9CB once
9CB.
before proceeding further. 9CB of the there.
Yes, 9CB. Yes, I am showing. I have already read that on the last one.
Let's come to that one, please.
Yes, 9.3. Collector shall also serve a notice to the same effect on such as belief interest in the land to the entire surplus or interest the position whereof has already been taken on requisition under subsection 3 of the Act, and notice for acquisition of such land has also been published under subsection 1A of section 4 of the said Act, and in every such case provision of section 4, section 5, section 5A, section 6, section 6, 7, section 8, and section 16 of shall be deemed to have been complied. That I have already made elaborate submission, because there are two types of acquisition that under the Act 1, under section 16 and 17 1A. Because 16 says after making an award and the position was taken,
section 4(1) notice was there.
yes,
Therefore, these provisions are waived. Let's come to the first and second provisions.
provided for that in every such case, collector shall make an award under section 11. That's why, my lord, I am showing 11 if the state of the land only for the purpose of payment due compensation to the person interested in such land has upon the collector taking possession already vested. So my submission was that
Therefore, there cannot be a lapse of the award proceeding.
yes,
Land has already vested.
and
Only the proceeding
Fine.
for the purpose of payment of due compensation.
yes, and it revives that amendment at 11A or the I am showing that 9C and 9CB that entire agreement lapse, it is not applicable because land has already been vested and it has been
So 9(3)B has to be read into 7A of 48 Act.
48
Act 2.
because 48 that
Yes,
the
40.
agreement 1990.
7A, section 7A
7A,
of
yes.
Act 2 says that if such a award is not made within such period,
418
the notice shall lapse.
notice shall lapse. So
Yes.
So, in that way, my lord, that I have already elaborately made submission on the last occasion that the amended provision, that is, my lord, the legislative provisions. Legislative provisions, my lord, revives that.
Read with section 9(3)B, second proviso, section with you may argue that although the notice shall lapse, but the vesting does not go.
Yes. Vesting doesn't go because it is a legislative involved.
Carries on only for the purpose of making an award.
Yes. Now, my lord, I will say that regarding 9C and 9CB that has been included within the study, if the award is not both, entire activity has also been amended in the 9C 11A. 11A. Can you see?
These amendments are of 1997.
Here also 11A it was amended.
Same, 97.
Same. Entire activity student. Now, my lord, I will show, because once position was and the land is vested, that 11A is not applicable.
In the special gain judgment was 9CB considered.
Special gain judgment, actually, my lord, 9, the honorable judges, my lord, only on the point that what?
No, 9CB was not considered.
9CB was not taken into consideration because there was no finding to that what will be the effect of the amended provisions, because whether the special bench only on the point that
So 9CB was not considered.
not considered.
Yes.
Although it is written, it is incorporated, but there was no discussion regarding. But because I should humbly submit, there was no. This point was not asked before the judges. My humble submission to it, because why the larger bench is, I should not say that, but it's to what extent, some extent, my lord, it is to be, because it is the ratio of decidenda is not applicable. President is not, because it is reached by the principle of parliament. Because the legislative, I have to, my lord, put the emphasis on the legislative, my lord, words. Legislative words revives my vestige. And not only that, when the honorable judges made consideration of 7A of Act 2, there was no existence of that Act. Now, kindly consider, this was a temporary Act, not a Act that is in permanent nature. After that, it was written.
When was it repealed?
31st March 1997. Well, I'll show that.
That is by virtue of?
But that not much of, but expense of time.
No, where do we get that permission?
Yes, I'll show. Can you take this book, Malad, because the legal laws, take it.
No, which provision? Just
I think Malad is not there.
no, it is under which provision? The first one, section 1.
The Chinese Malad, I not it. I do
Yeah,
not-
it is there.
It
Section
is there.
in section 1.
Sometimes
This was not extended subsequently.
no. That is an admitted situation.
31st March 1994 it says.
1997.
94 it says.
No, 1997.
There is a
Hey,
misprint here.
that's why Malad,
It's a misprint in this.
this print. That's why Malad, legal laws is very material. Time to time it was extended. After that it was not automatically by flux of time.
Yes.
Now, my lord, kindly consider first, my lord. Now, my lord, let us, my lord, why I am submitting. First, my lord, I made a submissions that the honorable judges, my lord, there was no occasion to read the provision of section 7A when the section 7A of when the entire act was not in existence. It is a temporary act. And in the Land Acquisition Act, when that act was there, Act 1904, there is no question of repeal or something because this is a temporary act.
But a new lease of life is given by 93,
Yeah.
93B.
93B, that's why I am submitting.
That extends it for the purpose of only the award.
And my lord, why I am saying that statutory period 93B, in case of 93B, that statutory period cannot be taken into consideration because vesting has already been there and revised by dint of legislative enactment in the 93B.
In your case, in this particular case, when was the notification issued? Under 418?
That is an admitted fact. My lord, admitted fact, my lord, 418 was issued. 93B was.
When?
My lord, at the material, but I will show, my lord, that fact I will show, my lord, on you.
Much before 1997.
Yes. And my lord, the larger bench mainly on
In the year 1993.
93.
you know, the fact আমি বলি
Yes, yes, thank you. Thank you. Right, yes.
So, my lord, it is an admitted fact. But that's why I'm saying admitted fact. 9CB was there. So 418 was there, 9CB was there. And my lord, kindly consider one thing, my lord, that the award was passed. But my lord, since the award was not delivered within that side 9CB, my lord, that my lord, I have already shown. My lord has already because have already gone into that the legislative enactment that if even 9CB there is a there is an amendment that if it is award be not passed within a certain period, then the acquisition should lapse. So that's why I am first ballot vesting remains, legislative. Then I am coming whether after vesting, because there is no question of acquisition, because state has become the owner of the land. And after vesting, whether any award with the, if suppose the award be not passed within a year, is applicable or not? I say humble submit, I humbly submit that my lord, the 11A is not applicable vis-a-vis 93A and 93B of the amended act, where the side of the entire acquisition. Why I am
The
saying
award was to be made not under section 11. Section 23 of the LA Act was to be incorporated as yardsticks for compensation. But Mr. Sengupta, the award is passed under section 7.
11. No, 11. It is there.
No, section 7.2.
7 no, 11. Man. I see the I have shown that the
No,
1948 Act. Yes,
Please come to the 1948.
yes, 19. No, regarding compensation 7 and other thing, Malad, 11 is also there. Malad.
The award has to be passed under section 7.2A itself. Please read
Yes.
section 7.2A. When the compensation 7.2 small a. Please read that.
Yes, yes.
Please
With
read
the
that.
principle, yes. When the compensation has been determined under subsection 1, collector shall make an according to principle set out in section 11.
So, in accordance with the principles set out in section 11, but the award is made by virtue of section 7.
Regarding compensation, absolutely.
7.2A says the collector shall make an award.
Yes.
In accordance with principles set out.
Principle set out.
So, the award is not under section 11, Mr. Sengupta, but
No,
under
that
7.2A.
clearly that it is malad is absolutely right.
7.2A.
But in a sense, that principle to be applied regarding the
Now, in your case, the award was not passed before the lapse of this 1948 Act. Award was not passed.
No.
So, you may have an argument in saying that this act lapsed.
Yes.
Therefore, section 7, there was no scope of award, passing any award. But under 9.3b,
Yes.
it will be a deemed fiction that the proceeding will continue only for the passing of the award.
Compensation and award.
But to that, your learned friend will argue that if it has already lapsed by virtue of the lapse of this 7-8 period,
Yes.
it had already lapsed before this act lapsed.
That's
1993,
yes, I follow.
so it already lapsed.
No,
before the act lapsed.
9CBA was issued after that. As per section, amended section 9CBA was issued.
9.3b notice was issued.
Yes.
Section 9 notice was issued.
9.3b, because after section 9, because 4.1a after that, because once 4.1a is invoked, 9.3b is to be issued. Once 3 section only requisition, 9.3a would be invoked. That is the 9.3a, 9.3.
Notice is under section 9. 9.3b says the collector shall also serve.
Also, sir, yes, and notice was issued. Is an admitted fact. So, madam, my humble submission, madam, this is, madam, kindly consider why I am saying that one's position, madam, I am not saying, madam, my submission is very limited. Limited to the extent that statutory legislative words has to be complied with. Because legislative word, it was not discussed in the, madam, the larger regarding what will be the fate regarding the legislative words, what will be the explanation regarding 9CB and 9CA? They are the larger bench also. 9CB will not be, but 9CA will be. This state is an applicable. Larger bench, yes. That 9CB would be not applicable, but 9CA would apply. That's the last part of the judgment. But there was no discussion, but that point was not raised. Again, madam, that point was not raised at all at that point of time. Because the legislative wording is to that effect that vesting remains. Even the 701A was there at the material point of time. Vesting in other words, notice goes, vesting goes if it is accepted, then even vesting remains. After 1997. That so far vesting was lapsed. If I happen to use a lapsed, again, that was, my lord, the legislative by the dint of amendment in the section 93B, that entire vesting shall remain. So otherwise there will be, my lord, it will be, my lord, redundant. Can you consider, if it is not read, then entire legislative purpose will be frustrated, that it will be redundant.
When was section notice given? Section 9 notice given? 9 3B notice?
93B. But it was, my lord, it was there. Just a minute. But it is there in the also orders. Well, I am coming. It's there in my reaffirmation of the report. Well, I have stated everything. Telephone exchange 41A.
April 18, 2001. 18th April 2001.
Yes, yes. But I am saying, well, I have written, well, the statement is there. And well,
My lord will find at page 144, my lord.
well, it is an admitted fact. That's not what I am saying. I
18th April 2001.
We do have
It is there.
October 17th October 2001.
No, but in this,
Calcutta gratitude are published, man. Not notified, given to me.
Oh, wow, this is funny.
no, but in this, in the application, in the section 5 application, the narrative is also there. There it is written that 9 3B notice was issued on April 18, 2000. Where do you find October?
That is notification.
Where is it annexed?
At 144, madam, please, 144.
144.
Yes, ma'am.
Thank you.
But after that, I will show entire facts, madam, that after completion my argument. The admitted fact. But I'm sorry.
No, page 144.
Yes, 144. Of that paper platform.
This is the notification regarding the Amendment Act. 144 is the notification regarding the Amendment Act.
So, look to next page, ma'am. By order provided to subsection 1A of.
No, we are asking for the 9 3B notice.
So 90 notice was never given.
They have made out a case that in April, on April
No.
18, 2001, in this section 5, they have stated.
No, that's not the one.
Well, it is there and the portion back now. I will show and I will show the mallet. I will place the documents. Mallet, now mallet, I am handing over the mallet, the special in the development. Mallet, to show, mallet, there are three things I will show. Mallet, first mallet. First mallet, so far these judgments are concerned. this constitutional dialogue. Well, the section 24 or 1A of Act 2013 is neither has been interpreted. And section 114 of 2013 Act has also been interpreted. And section 20 by interpretation, the Supreme Court, well, this is the development of law regarding by our interpretation by the Honorable. Well, section 24 there in the section 24 says that if the proceeding be not 5 years or 50, then entire acquisition proceeding should lapse.
In the development, it was a different concept. In the
Different
development, by virtue of coming into force of the 2013 Act, the Act 1 was repealed. Now, the question arose whether even after repeal, what will be the position? Now, there it was held that automatically the proceedings for grant of compensation will continue. That will be deemed to continue.
Yes, that apart from that,
how is that relevant in your?
Relevant, why I am saying, madam, indoor development, not only that, indoor development also made a consideration what is the effect of 11A in case of vesting under subsection 17(1). So I say it's a parameter. 80% compensation has to be paid. It is there. It was there. And here 17(1) is also there. And in the actually, sorry.
No, sorry. This 9CP notice and the compensation payment are these on record?
Yes. It's a record. Award was passed and also. But I will show the facts, I will show that is an admitted fact. So that means the award was not passed within a
I'm sorry, Mala. That is what to do sign notice was given to us,
yes.
which is at page 142.
18th April.
18th April. I'm sorry.
No. No, that maybe.
Yes, 9CB, yes. But that is an admitted position. That's why but I am concentrating on the law point, that's why I am admitted fact only.
Yes. Right. Yes, Mr. Chair.
Indoor development, mainly the development of law that by your interpretation of section 24, that what will be the consequence regarding whether the entire acquisition should lapse or not. By reading section 114 of the Act, Indoor development says there in the section or was there if no compensation was paid.
If you want to rely on a particular paragraph,
paragraph, kindly come to paragraph 97. Because in the section 24, or was there. Or was negative, it should be and. So both has to be completed. If no negative was, the two negative was. If no award be first and no compensation.
Physical person and compensation.
No award be first and no compensation, then 2013 Act will be available. If one of them is fulfilled, then 2013 Act will be available. And the proceeding will go on.
Yes.
97. Comes an exception where the award has been further proceeding but pending, but in the such way physical portion land has not been taken or compensation has not been proceeding shall lapse. There are twin requirements for the lapse. First, the physical portion has not been taken, and secondly, compensation has been taken. In case of possession has been taken, but compensation has been there is no lapse. And can you see last part 4 or 5 lines above for the bottom? Furthermore, are to state when two negative conditions are connected by or, they are construed as cumulative, and the word is to be utilized as nor or and. Naturally, landowners are to the contrary, the lapse on if the compensation were not paid or position of 5 years before the coming of. So, if in the cutoff date there is 5 years or more. even Supreme Court held the development of law that no, both are being fulfilled. The position was taken because not in touching of Act 1, not in touching of other act. But my lord, I will show even temporary act. If the vesting, my lord, it is revived by subsequent legislation. This is a constitutional bench, I think. This is why I got it in 1962 and I expressed that. But before that, here, apart from that, 97, my lord, 2119, it has been, my lord, 2119, my lord, I will not, my lord, waste my lord valuable time. My lord, everything has been discussed up to 119. Well, kindly see, last matter, kindly see page 119. Kindly turn over the next page. Page, paragraph 119. Sorry, paragraph 119. Right. 97 to 119. But I do not want to waste my lord valuable time. My lord, page, paragraph 119. Got it, madam?
Yes.
Then my turn over the page. Section 31 to deposit under section 32, compensation has to be paid along with interest and due to non-compliance of section 31. There is no lapse of ability. Same spirit has been carried forward in the 2013 Act by provided section 24(2). Once position has been taken, though payment has not been made, compensation has to be paid along with as emphasis under section 34. 34 means 34 of the Act 1. And in a case, payment has been made, position has not been taken, there is no lapse under section 24.
Sir, there is a difference between the language of 7A and 11A. 11A says that the entire acquisition proceeding shall lapse, in which case your argument will be relevant because the acquisition proceeding does not lapse because of the vesting. But in 7A, the language is the notice shall lapse. Not the, if the acquisition proceeding shall lapse was used, then this logic would apply.
But in the 9CB is there?
But section, no, 9CB, even 9CB is there.
Because amended.
In a case where the acquisition proceeding has not, the notice had not lapsed, 4(1)A notice had not lapsed, but the statute itself spent its force, 97, then it would be revived definitely. But if the notice had already lapsed, here we are looking at a situation where the notice had already lapsed when you gave the section 9 notice. So whether that can be...
Yes, subject to matter 7. Kindly consider, even it is a temporary act, but by dint of amended in the Act 1, that vesting revives. So even if notice shall doesn't kindly consider the notice shall lapse. Well, there are two things. Notice includes vesting at that point of time. So my lord, after amendment, 90, whatever my lord will take into consideration what is the legislative intention regarding vesting, which was even for argument's sake, but not admitting that was divested. That notice is the notice lapsed. But my lord, here the legislative wording is to the effect that vesting remains. So my lord, this is one way aspect. So if the vesting remains by a legislative wording, then there is no question of going backward of a temporary act. Because temporary act, my lord, kindly consider there are fundamental difference, though I will show that judgment of the constitutional bench judgment. If the right act is and that has been again approved, or the legislature by the vesting remains, then my lord, even if the right act was it will revive, even it was a temporary act. My lord, here my lord, I am so my lord, first of all, my lord, even the development of law regarding 2030, regarding interpretation of section 24 and all other provisions, 114, there is section 6 of General Powers Act to be applicable. My lord, there was nothing in this 2013 Act which says whatever position was taken, entire thing will go. Rather, section 6 of the joint clause of legal. If anything done or you knows that with the right action, seems to because retrospective effect only it has been dealt with in this language. Retrospective effect has to be specifically stated. There is a judgment.
Why is the question of retrospective effect here? Here already the notice had lapsed because 3 years had passed before the act had. It lapsed in 1996 before 9(3) came into force.
Before 1993 came into force, time consider.
With the notice, the vesting also lapsed.
But if the
Before
notice
this came into
in
96 itself, the position was Mr. Sengupta, notice and vesting goes. The vesting is tied up with notice.
But 1997, that is the as soon as the before expiration, amendment has come into effect, incorporated in the position in section 90 and 93. What will be that? There the legislative years, the vesting remains. It was not discussed in the judgment. That is my submission. And kindly was the development of law. That the even 93 and 93 in section incorporated in section 11A. There the same thing was there. Entire acquisition proceedings to lapse, even 93 and 93. So even my humble submission before my lord, if the vesting remains, if the position retains with the owner, or that is the government, then my lord, section 11A is not applicable like was 93B of the amended act in that section 11. That I show you because it is parameterial to section 70. Even if no compensation was passed, no award was passed. That I will show my lord in this chapter. Though my lord it is in touching with the 17 one. But I am submitted that the is parametric. My lord has already gone through the scheme of the Act of 1948 as well as the 17 one of Act 1. It is borrowed. Now, my lord, because in the Act 1, section 16 was there, and deeming provision it was gone in 93. My lord has already seen. So there is no requirement of further making an award, only to make an award and compensation. If there is suppose 20% or something like that interest part and everything, even section 18, they can approach. That is the reference. Not that they are the remediless. But kindly consider here, I will show my lord 136 paragraph that is regarding vesting. That's paragraph 136. My lord, this was a 3-man bench judgment. My lord, again, my lord, 2-man bench judgment has taken my lord a contrary view because unless compensation be paid, compensation shall is there 50%. If it is not, if it was not being paid, then my lord the vesting goes. But my lord, the constitutional bench judgment held that Jai Satyendra Prasad Jain is absolutely logical. Well, I am ready 136 page, the paragraph. So, in Satyendra Prasad Jain and state of the concept of vesting under section 18 had been taken into consideration. Whereas the government cannot withdraw from acquisition under section 48 once it was taken a position. And position is one of the vital part in the matter of taking acquisition. That the legislature, when they have amended, that was in their mind. That entire position was taken. That's why, my lord, even 90, there I show, even 90B was not invoked. And the material part, even 90, it was there already possessed. So that was in their mind. That entire thing will, my lord, will go. So amended was to the effect that the vesting remains and yes, you can get compensation, you can refer them under section 18, everything is there. But kindly see, Shraddha has taken in consideration government and cannot withdraw from acquisition under section once it is taken into position. And see, I am referring to the emphasis of position. This court has observed once position has been taken under section 17(1). Malad has already read. Prior to making of the award, this is very important. Prior to making an award, and likewise, Malad section 418. Prior to making an award, land is vested to the state become all land. The owner is divested of the title of the land, which is vested to the government, and there is no provisions by which land can be reverted to the owner. This court has observed there are two judgments of the we must note, Galston such and such. It was that government could not withdraw from acquisition under section once it had taken the position of the land. Such and such. It was said after position has been taken pursuant to the notification of 17(1), land is vested in the government, and the notification cannot be cancelled under section 21 of the General Powers Act, nor can the notification be withdrawn in exercise of the powers under section 48 of the Land Act. Any other view would enable the state government to circumvent the specific provision by relying upon a general power. When possession of the land is taken under section land based in the government, there is no provision by which the land territory vested in the government refers to the original power by mere cancellation of the notification. Ordinarily, the government can, well, this is very important. Ordinarily, the government can take possession of the land proposed to be acquired only after an award of compensation in district has been made under section 11. Likewise here, upon taking possession of the land based in the government, so award simultaneously possession. After that possession, then land based. But the what before my page passing an award is the land vested to the state. There is this total different scenario with that. Kind of see, upon taking possession of the land based in the government, that is to say, owner of the land loses to the government the title. That is what section 16 says. That's why I made up. Likewise here, 11, because in that acquisition, great may not because he has to cost an award. Under section 11, the principle would be applied. Compensation part will be governed by section 7. And when at 80% was there, compensation 8B. And it has not been touched. Because position has already been taken away and 80% compensation was paid. Does it mean, my lord, that the thing, because position is one of the things to be taken into consideration. It's a vital part. My lord, kindly see, in ordinary case, therefore, when the government fails to make an award within 2 years, that is important. From the date of declaration of under section 6, land still not vested to the government, as title remains with the owner. Acquisition proceedings are still pending, and by virtue of the provision section 11A lapse. Likewise, 9C, 9CB in the amended portion 11A. Well, when section 17(1) is applied, by reason of urgency, the government takes possession of the land prior to making an award under section 11. And thereupon the owner is divested to land which is vested to the government. 17(1) states has no unmistakable terms. Clearly, 11A cannot have no application to cases of acquisition under section 17 because the lands have already vested the government and there is no provision in the state act by which the lands territorially vested in the government can revert back to the owner. Then 80% estimated amount, if it is not paid, this judgment here, no, it is not, doesn't matter. Doesn't matter. Award because doesn't matter. So, my lord, I am humbly submitting that this principle will be applied in my case also. Because it is parametric. And my lord, 97, 136, 136. Kindly come to page 149, paragraph 149 of that judgment. 149 paragraph. It was taken into consideration under section 24 of 2039. Even Malad, kindly see this court. This court is of the opinion that section 24 does not intend to take as vested rights. This is because there is no specific provisions. You know why I am saying? Because in the repeal and saving Malad, there is no specific. I have already made submission. There is no specific provision by giving retrospective effect that vesting goes. When taking a divesting title of the land, which had originally vested with the state, or divesting the title or interest beneficiary third party transfer of such land which they have lawfully acquired through sales or transfer, there is a specific provisions made for divesting, not just 2013 Act by necessary intent. One is by specific provision and by necessary intent. That is the construction of the Malad disciple interpretation. Necessary intent. Even necessary intent 2013 doesn't say that whatever vesting was there, that has been taken out. And in my case, is better than that. Vesting stood affirmed by our legislative, but this is not my this legislation. But can you see in our concept, Malad, I did not read the entire judgment, but Malad, the principle Malad, and Malad kindly come to page, paragraph. Yes, Malad, 152, paragraph 150. I have made a submission, section 6 of the it is inbuilt in the 2013 Act 11. It was discussed. Paragraph 150. Section 24, 2 of the 27 is to be interpreted consistent with the legislative intent, particularly when it was provided for the lapse of proceeding. It has to be interpreted in the light of the provisions made in section 24 and 114 of the. It has to be read as a whole. 29 and section 6 of the General Clause Act, what it protects and to what extent it takes away the rights of the parties. Undoubtedly, section 24 has retroactive offense with respect to the acquisition initiated under and which are not completed by taking possession nor compensation. Two things. If it is not, as specifically stated, and if the two things are not happening, then my lord, 2013 Act. If one of them is there, then no 2013 Act. It will be initiated, and I will show the three men later. After this, the constitution. But in spite of lapse of 3 or 5 years, and take into lesser job, the drastic consequence followed by consequence. So, my lord, it is the by our interpretation of section 24 and all provisions and 114, that is the repeal and saving. At 2, if the position is not taken, nor, that's not, or and. It should be nor, or instead of or, it should be nor or and. Both of them have to be fulfilled. If one is lacking, no application of 2013. Now I am showing manner regarding the effect of that lapse due to a flux of time. What is the fate of the regarding temporary act, which is gone by a flux of time? When I am referring AIR 1962 Supreme Court 9 for this is constitutional. 1962, AIR 1962, Section Report 945. Well, straightway kindly come to my pay paragraph 21. Well, in fact, I will tell my letter on my letter. My letter will also my letter can get. In our opinion, yes, in our opinion, it would not be reasonable to hold that the general rule about the effect of expiration of temporary act, which Mr. Chen relies, is inflexible and admits of no exception. It is true, for instance, that offences committed against the temporary acts must be prosecuted and punished before the act expires. If a prosecution has not ended before that date as a result of the termination of the act, it will ipso facto terminate. But is that an inflexible and universal rule? In our opinion, what the effect of the expiration of temporary act would be must depend upon the nature of the right or obligation resulting from the provisions of temporary act and upon their character, whether said right and liability are enduring or not. There is a difference between the temporary statutes and the statutes which are repealed. The latter, except so far as they relate to transaction already completed under them, becomes as if they had never existed, but with respect to the former, the extent of restriction imposed and the duration of the provisions are matters to construction. In this connection, it would be useful and interesting to consider the decision for the case of Stevenson. In such and such, that the case related to 6th of GO 4 section 4C133, section 4 which provides that every person who held a commission or warrant as surgeon or assistant surgeon in His Majesty's Navy or Army should be entitled to practice as apothecary. None of that just work doctors. Apothecary. Well, without having passed the usual examination. The statute itself was temporary. It expired on August 1, 1826. It was urged that a person who was entitled to practice as an apothecary under the Act would lose his right after August 1, 1826, that is the expiration of the temporary. Because there was no saving provision in the statute. There is a saving provision that in the amended Act. But I am saying there is no saving provision. Even in that, my case is better than that. But there is saving provision in that. Yes. Because there is no saving statute. Its expiration would bring to an end of all rights and liabilities created by it. The court rejected this contention and held that the person who had acquired a right to practice as an apothecary without having passed the usual examination by virtue of the provision of temporary act would not be deprived of his right after its expiration. In dealing with the question about the effect of expiration of temporary statute, Lord Ervinga CB observed, it is by no means a consequence of an act of parliament's expiry that rights acquired under it should likewise expire. Take the case. Well, it's not parliament's duty. Well, take the case of a penalty imposed by an act of parliament. Would not a person who had been guilty of the offence upon which the legislator had imposed the penalty when the act was imposed be liable to pay it after its expiration? The case of the right acquired under the Act is stronger. Section 6 GO Satan provides that parties who hold such warrants shall be entitled to practice as apothecaries, and we cannot engraft on the statute a new qualification limiting that enactment. It is in support of the same conclusion Parker B made the observation which we have already cited. We must look at this act. Observe Parker B. See whether restriction 11th clause and the provisions of statute only to last for limited time is applicable to this privilege in question. It seems to me that meaning of the legislature was that all assistant surgeons who were served before the first time should be entitled to the same privilege for practicing apothecary, as they had been in actual practice as such on August 1805. That privilege as such was of executory nature, capable of being carried into effect after August 186. Take the case of penalty imposed by a temporary statute for offences created by it. If a person is tried and convicted under the relevant provisions of the temporary statute and sentenced to undergo imprisonment, could it be said, as soon as the temporary act expired by which pass of time, the detention of the offender in jail with virtue of the order of sentence imposed on would cease to be valid and legal? In our opinion, answer which has to be in the negative. Therefore, in considered effect of the expression temporary statute, it would be unsafe to lay down. It would be unsafe to lay down any inflexible rule. It would be unsafe. If a penalty has been created, taken out because the statute by which it was expired cannot be taken out. The right cannot be taken out because the statute by which it was created has expired. Statute has given me the right of justice. Amendment Act, that is 93 and 93. Then, paragraph 22, the question sometimes arises in another form, as Grace has observed. If an act which repeals an earlier act is still a temporary act. The general rule is that earlier act is revived after the temporary act is spent. In as much as a says hypothesis, the temporary act expires and is not repealed. The rules of construction laid down section 11(1), section 38(2) of the Interpretation Act 1889 do not apply. But there will be no revival if it was clearly the intention to repeal the earlier act absolutely. Therefore, even as regards the effect of repealing of an earlier act made by a temporary act, intention of the temporary, here my case is better than this temporary act may not revive. Here just opposite. Temporary act gone. Right regarding vesting remains. Even my case is better than that. Here temporary act revives that. Even in that case, Supreme Court says no, that will remain. Temporary act and no general as this one. The intention of the temporary act in repealing the earlier act will have to be considered, and no general or inflexible rule in that regard can be laid down. This position has been tersely expressed by Lord Ellington when the observed in Warren versus Mendel in such and such a law, though temporary in some of the provisions, may have a permanent operation in other respects. Statute such and such professes to repeal the statute 19 absolutely, though its own provision which is substituted in place were to be only temporary. In other words, the decision shows that in some cases repeal effected by a temporary act would be permanent, would endure even after expiration period. We have referred to this as a matter why by your analogy to show that no inflexible rule can be laid down about the effect of expiration of a temporary act. My only so that ordinance paragraph 23 says that after discussion everything, because ordinance the municipality that election was nullified by the court. Ordinance revised that. Ordinance expired. Now the question arose whether whatever affirmation was done by kind of ordinance, whether that will be kept alive. Supreme Court says yes. Ordinance may be taken. So my case is better than that. Because the Act 1 is not a temporary act. Act 2 was a temporary act. It has been revived. Particularly, my lord, why the legislature on its own thought it fit? Because they knew before the drafting of that amendment. Because their position, what will be, there will be series of anomalies. That was in their mind. That's why positions still remain. Apart from vesting, I will show 9CA now. Some of the provision I did because whatever I have found, that is against me regarding the strength of the basis. That but here also interpretation is there. Whether court is debarred, suppose a law which is in open minors is totally unconstitutional. And another thing that is constitutional, that is to be constitutional. So minors can lean towards the.
That would create judicial anarchy.
Yes, that is good. But whatever, I am not on that. No.
Every other judge the next day comes and feels the law is different.
Now, my lord,
Change a larger window.
now, my lord, this is very important aspect. My lord, I do not know how the Supreme Court has, my lord, it is very peculiar, sir. My lord, this judgment was challenged by the State of in some of the matters. My lord, kindly see. This is, my lord, I think,
Which
my lord,
judgment?
this is against the judgment of the judge.
Acha, that was challenged.
That was 10.
What happened there?
Well, kindly, well, I do not want to kindly see. First of all, my lord, the respondents, my lord, they sought for, my lord, intervention that the compensation to be governed by the 2013 Act. Supreme Court rejected. How a Supreme Court says that and the date was fixed that this date is to be the turning point. But how, my lord, I do not know. But kindly see, come to my lord, yes, copy. Yes, copy. Answer on these. Act on these. Madam, kindly see, first, madam, kindly see in this group of acts filed by the state of Gujarat, land of dismal requisition under section, madam, that is the madam 1948. There is the admitted fact. Say, madam knows that because 9CA, 9CB was discussed before the larger bench, madam, and against that state preferred in some of the cases. And madam, not only that, the SLP has been converted to a civil appeal. But here, if I permit to use that, kindly fix a date. That is the date for determination of the amount. Malad can do that. Kindly see. 4-1A, Malad is ready. Malad, may I
Wait.
Yes. Position, yes, that is for construction of public road in the district of South Chula. That is under the Act 40. Position of the land was taken and the same stand utilized for the same purpose. Thereafter, proceeding for acquisition was initiated. Notice under section 4-1, at that time, 1940 was issued and proceeding was needed for making the award by issuing notice under section 90 as applicable in the state of West Bengal at the relevant point. Because the honorable judge, the latter will says no 90, not 90, but 90. Because honorable the latter bench, not 93, but 93 can.
Because 4-1A notice is gone.
Yes, 4. But when there was no consideration of the amended portion 90 and 90. There is no interpretation even. Malad, if I may permit to use that. Malad, kindly see. Notice, sorry.
Yes.
Notice, respondents approached the High Court by way of several requisitions with the prayer for return of the land after declaring the acquisition proceeding had lapsed. A civil appeal number, that is a civil appeal number, Satansa, learned judge of the High Court, Satansa, held that as a result of lapsing of the proceeding, compensation be calculated, taking in 18 months 19 as the date of culminating, determining the market value of the for the compensation. Same date was the date of notice under section 90. And the of the local amendment as applicable to the state of Oshawa. This view has been affirmed by the division bench of the High Court. Division bench then larger because contrary views were there. In the course of hearing of the group of evidence, it could not be shown that the finding the land acquisition proceeding had that in any manner erroneous. There was no challenge. All other proceedings that the section 4-1 was not there, section 5 was not there. That was not that. Their whole intention that whether lapsing will occur or vesting will go on. By consideration 7. It was the lease was there. Entire lease was. So in that it is not a Supreme Court finding. It is not fine. It also could not be questioned that it is not viable to restore back the land back to the respondents. The order of the learned single judge referred to have not been questioned by the respondent. Only the state has questioned the same. In this circumstance, the question is hereby where interference is called for with the direction that the respondent be given compensation at the market value as on 18th March 1999, deeming the proceeding of acquisition to have validly completed. So, my lord, after that, my lord, that the dealing clause, my lord, was applied by the Supreme Court and Supreme Court consent. So, my lord, it is very much, I should after all, it is the Supreme Court judgment. But, my lord, only thing, my lord, so my lord can fix a date because 56, 57, 70, 80, 90, my lord, so many position was taken and so many award was passed. So many 80% composition, even 100% composition, maybe. So, my lord, kindly consider, so my lord, absolutely, my lord, the ratio now it is the merger will be applicable.
Mr. Sengupta,
Yes, my lord. Because I was very.
no, apparently the three-judge bench seems to be the best view. Why you are telling it?
Yes.
So that we can,
Yes.
we are putting it to you. Now, there are two scenarios. One is that the section 41A notice is issued. Requisition is there, possession is with you, there is no doubt on that. It is not a question of possession then. Section 41A notice, acquisition happens, and then you have to pass an award. But section 7A says if that award is not passed within 2 years, then what happens? The notice shall lapse. What notice? Section 41A notice shall lapse. The requisition still remains, the land, possession of the land remains with you.
Yes.
Therefore, 9A and 9B contemplate two different situations. 9A says if there is no section 41A notice, then it's a required land. Then that 9.3A notice is the date of calculation of compensation. And 9.3B says where there is a section 41A notice, then something else that initially. Now, by virtue of before the temporary act spent its force or the new amendment of 9.3B came, the notice had lapsed by virtue of 7A. In your case, notice had already lapsed.
In most of the cases. Not in my case, in most of the cases.
No, in your case, that is.
Yes, yes. I am saying, I am making a humble submission in most of the cases that, yes.
Maybe. But now 7A, when that lapse happens, the notice lapses, so it reverts back. If the notice is not there, on the lapse, the section 41A notice is no longer there in the eye of law. Therefore, it's not a situation where 9.3B comes in. Because 9.3B says where 41A notice is given, that notice is itself made defunct. Then it reverts back to 9.3A, obviously.
Yes,
Then you're still then, the possession remains with you. You are entitled to take that, you acquired that land, but then the date of compensation will
Then,
be
what is the date of the commission? Tell I am because
from the date of 9.3A notice.
Because I am
as per 9.3A.
as
9.3A is applicable.
I am making humble submission. Suppose
It will be as like a situation where there is no section 41A notice. Because of lapse, there is no section 41A notice in the eye of law. Therefore, 9.3A applies. Which says requisition taken, no section 41A. Possession remains, therefore section 41A notice. Even then, it is not taken away from you. But then the date of you will still pass an award and acquire the property. But then section 9.3A notice is the date of calculation of compensation.
Madam, may I submit?
That is the only view possible.
May I submit?
Yes.
Kind. Because, my lord, I think, my lord,
just think over it and we will hear you on this. So this is our triumph.
Yes.
Yes.
My only submission would have, my lord, only thing, my lord, what I am, sorry.
No, it's only one thing. Special bench judgment,
Yes, yes, but then
larger bench judgment
Yes,
was in
in all three appeals, my lord.
oh,
Yes.
because the names are not telling. that's
Yes,
it.
yes. Yes, sir. Because there are three appeals. Preferred by the
Right.
state also.
All right.
In the respect of, the 4-1 was
So
invoked.
one you have got
Yes.
copy of.
So, my lord, basically,
All right.
so basically, my lord, what happened regarding law point? My lord, first of all, my lord is absolutely right. Yes. My lord, kindly consider one thing. This is, my lord, not disposed of at the SLP.
This is
So it is a march. My lord, kindly, 2019 Supreme Court cases as a larger bench judgment held. If it is converted into civil appeal, into one line order, it is a march. The march is having civil is happening. So in this case,
but the order was not, judgment was not set aside.
the judgment was not a but.
No interference.
No interference. But what I am on. No, but what I am on. There the my lord, kindly come to having regard to the entirety of the situation. My lord, that is the order dated. My lord, next.
Yes, yes.
Having, there is a third paragraph. Having regard to, sorry, it starts with having regard.
I mean, they are
30th November 27. Last page, that is last page, no, that is last two pages. This starts with Mellor, State of West Bengal versus Lakshmi Rani Farm.
all of them start with that.
Yes, yes, yes. All Mellor, same Mellor.
Having regard to it.
Converted into civil appeals.
In Pakistan.
But having regard. Mellor, I am
Having regard to the
Yes,
entirety.
having regard to the entirety of the situation, High Court by impugned directed determination of the market value. That is, my lord, the division bench, which has affirmed saying that no vesting. Virtually, my lord, it has been affirmed by the Supreme Court. But kindly see what I am on,
It has
because
been affirmed there.
kindly
We affirm the same.
well, kindly see, having regard to the intent of the situation,
Yes.
High Court by impugned directed the determination of market value as on 18th May 19, deeming the acquisition property to have validly completed, we affirm the same. So, my lord, in a case, that is my case, support my case. But kind of what I am on. Because Supreme Court is a deeming provision. There was no in the statute, there is no deeming provision. Supreme Court say affirm the views that following which the division bench accepted the division bench. Other judgment didn't accept. That's why larger bench it was larger bench had no. 9-3 gone, but 9-3 you can have. But Supreme Court affirmed the view of the judgment of the honorable single judge that was affirmed by the division bench, which was not affirmed by the larger.
Mr. Gupta, sir, the
But I follow. Now
9-3 and 9-3 only reaffirms whatever is there.
yes, I am coming.
Let's complete the sentence.
Yes, yes. And kindly consider one.
Let us complete the sentence.
Yes.
9-3 affirms whatever is there in the 48 Act itself.
Yes.
Suppose the 48 Act did not spend its force, it was still pending today. Even if that be so, the effect is that you require the person 3 notices there, you take possession by requisition, 4-1A notice given, lapses after 2 years. After lapsing, what happens? That's why it's stated there is no question of the vesting separately lapsing. Notice lapses, there is no acquisition initiation. It reverts back to the stage that you had requisitioned the proceedings and so you have to give a fresh notice in any event under section 4-1A. You had to give a fresh notice under the previous act. That position has already been reiterated, in 9-3A. And your right is saying that the act has been revived in a sense to that extent.
Madam, what I am on, I is absolutely right.
So that is the only thing.
Yes, madam. All the thing, madam, kindly come to 9-3A, madam.
In this case, the learned judge has done what? In your case, in the impugned order?
Learned judge first
has directed
they didn't consider actually in total. But
ultimately, what was held?
2013 in all
that probably is not correct.
2013 and learned judge, honorable single judge held that the division bench initiate, well, that is one way submission I have made. If it is
So
initiated
subject
under
to hearing them, Mr. Sengupta, we can say this because 2013 Act does not apply. Simply stated because this is not an acquisition under the LA, under 48 Act. 2013 Act contemplates only Section 4, only LA. So 2013 is not applicable. So then what remains is 93A
now
will apply.
50% gone. 50% because I have already successfully completed
50% you win, 50% they win. So
Yes.
we will say that 93A
Yes.
will be applied, and the date of that 18th of April or whatever, that will be the date for on which the market value has to be assessed, and then award will be passed within a limited period.
Absolutely, absolutely. All
So
right.
we will do that only.
But kindly consider one thing. I mean, I am
Unless
showing that-
your other side has to say something else.
Yes, he will say because the 2013 Act. Oh, he just said he may prefer an appeal because restored by convention. I think so.
Yes.
Restored by convention. And that is one thing, my lord, I would, I need
So
not.
there are two appeals, one by you and one by them.
I want to restore the convention.
Then we have them independent.
Kindly consider one thing. 9-3, again, my lord, kindly come 9. 9-3 of
We have to follow back upon 9.
9-3. Here also, my lord,
Yes.
here position was protected. Kindly. Here also, 9-3.
Exactly. That is
Yes.
what we are saying.
Yes.
Position has not been taken away.
Yes.
It has been said, it has been revived, so it reverts back to the position when requisition was done. You were in position, and from then on, this notice under 93A is the notice of acquisition. It substitutes the section 41A notice basically.
I follow. Well, I kindly see whatever. I just read Bharat, kindly need not go.
No, read
Need
it.
not go. Collector shall also serve a notice to the same effect on such a person believed to be interested on the entire to act so interested. The position whereof has already been taken on requisition. So it has also position was taken care of. And my lord, what I am on 9-3, my lord, kindly consider these things, my lord, this is legislative intention to revive. Suppose even if
If there is a section 41A, then 93B comes.
yes, section 418 in this case, section
In
418.
your case, it has lapsed. It had already lapsed during subsistence of that statute. So the effect will be as per the special bench, larger bench, that there is no section 41A notice. There is no valid section 41A
Well,
notice.
at 9, I will show the paragraphs regarding admitted facts when that 9-3 notice was issued. After that, in terms of section 9-3B, because kindly consider one thing, my lord, my lord is absolutely
We
right.
constitute that 93B notice to be under 93A.
That I know. That I know.
Therefore, we'll save your position, but you'll have
But
to
when
declare for
make my lord's observation regarding whatever this is absolutely the judge didn't take into consideration of 9-3B. Because
No, larger bench took into consideration. Mr. Sengupta, we understood the judgment later. In fact, while thinking, larger bench did not say it in so many words,
yes,
but did not apply 93B, instead applied 93A.
9-3.
Why? Because if the notice has lapsed already, then there is no valid notice in the eye of law under section 41.
Yes, I follow. But 9-3B, one of the
93B comes in only when there is a notice under section 41.
418 because can you consider? At that point of suppose, my lord, admitted fact is a temporary. Well, at that point of time, that notice lapses or not, or it is revives or not, my lord, it is, my lord, almost gone. So after expiration of the temporary act, 31st March 1990.
The lapse took place before that.
Before, no, I'm coming.
So the position was when the temporary act spent its force, that act lapsed. At that point of time, the position was you had a requisition under section 3, but no acquisition notice under section 41A because of the lapse.
And my only humble submission before my lord. There was no act at that point of time when the matter.
No, that is revived by 93A.
9-3A and it should be, my lord, taken to the 9-3B also. But why?
93A and 93B operate in separate footings. 93B only when there is a section 41A notice, 93A when there is no such notice, but requisition is there. That is the position you are in when the act lapsed.
Well, what I am on, something else saying right now. Well, 9-3B, what I am saying, even divesting has been reaffirmed by a vesting in 9-3B by legislation. What I am on, Even vesting gone, again it has affirmed that vesting has already because referred back to the state by dint of invoking section
If
93.
there is a section 4.1 notice.
If there is a section 4.
In your case, there is no section 4.1 notice because of the lapse.
No, section 4 notice was there.
No, no valid section 4.1.
4.1A because that
That has
7A.
lapsed. Lapse means it goes,
Yes.
evaporates,
Yes.
does not exist in the IOP.
Yes.
So there was no section 4.1 notice, therefore section 9A was applied, 9.3A was applied.
Yes. 9.3 I have followed.
Absolutely correct.
Absolutely correct. But the legislative intention that it would be redundant. The section 11.
No, legislative intention is very clear.
Yes.
If there is a valid section 4.1 notice,
Yes.
we have to read the expression valid into that because section 4.1 says there is a notice. 7A says notice will lapse if 2 years go. Here 2 years went by,
Yes.
no award, lapse. What is the effect of? We have to also give meaning to the legislative intent of section 7A.
Yes.
Otherwise 7A would have no meaning, redundant.
But 7A has been, my lord, has been done away with by section.
That is where we do not agree with you, Mr. Shenmuthu, with
But I
respect.
can make my lord's observation, my lord, I am not.
We'll have to, because
Yes.
that is your argument.
Yes. My lord, my submission, my lord,
7A cannot be retrospectively made redundant.
and my lord, one thing, my lord, I am because
And that is your judgment, the judgment you cited, that says so. That whatever has already inured under the previous temporary act, that's a distinction between a temporary act and a repealed act. Repealed act did not exist in the eye of law. But temporary act, whatever happened under that act, that endures. There is a language used.
yes.
So what happened under that act? Under 7A, lapse already occurred. And what happened? It reverted back to the requisition stage. The section 4.1A notice is no longer there, it has lapsed.
I followed 4.1A because
So therefore,
cannot be said
so that position occurred
Yes.
before the temporary act lapsed.
lapse.
So
Yes, but I
therefore,
have-
whatever happened, that position would endure
Yes, I have followed.
as per your this constitution.
I have followed. My lord, I know.
If you have followed
it
it,
will-
then
I know it will go against us, but my lord, it's something because it also it comes both ways. Because that's why, however, my lord, I have because as a judicial officer, my lord, I have to, my lord, so there are all the points, all the cards to be kept open before.
as a legal officer.
Legal, sorry, legal officer. Legal officer. My lord, now, my lord, kindly consider one thing. My lord, the judgment, my lord, has already seen. My lord, I am handing over. My lord, that is, my lord, even suppose the development of law. Suppose before 1/1/2014, the Act 2013 has come into effect. My lord,
Why are you citing the judgment?
because why? Because the legislation, because the development of law. Because even in that case, by taking into consideration of section 114 of the, my lord, the 2013 Act,
Yes.
my lord, it has been held that acquisition proceeding didn't lapse. Only on yes,
You're right.
Yes.
Acquisition proceeding did not lapse.
did not lapse.
Here the consideration was whether it lapsed by virtue of the repeal.
My lord, here
We
my
are
lord,
also saying, I mean, here it's not a question of repeal.
yes,
And your Supreme Court special constitution bench says that
yes,
difference between temporary and repeal. 48 Act did not go by repeal.
No.
It went by lapse
and
because of temporary. So that's
but
the
I have
distinction.
followed that section 41 if it is that because only the position that has been affirmed by or that has been my lord accepted by the legislation, the wording of the legislation is concerned because that has been happening. Position remains. So my lord, I am on that. My lord, so my lord, kindly consider again my lord the
Which paragraph of
petition.
this? Which paragraph, Mr.
Oh yes,
Haryana State?
yes, yes. The Haryana state my lord, that is just a minute.
Yes.
Just a minute. Page 40, page 39, paragraph, sorry. Paragraph 39.
Yes.
39, my lord. Now we'll consider the other common question involved in the corruption appeals. The pertinent to question as to whether section for notification issued under section prior to 1/1/2014, date of commencement of 2013 would continue or survive after 1 as to whether Section 6 notification of could be issued after Section 1 after 1/1/2014. Now, my lord, the Supreme Court held after considering all these things that everything only the compensation part to be governed by the Section 26 of the LA. Right, that is 2013. Only compensation. Right, they can carry out because it
No
is-
doubt on that.
So this is the principle, my lord. The development of law, not that the acquisition, and my lord has accepted that acquisition should remain, but my lord, now my lord considered only one. This was my lord not less than 20,000 crores a year. This so far this matter I am not considering because so many matters are pending and judgment were passed.
Total 20,000 crore. Taking into account all those.
Less than 20,000. All over West Bengal, I am talking. Blood and one after another, order was initiate process under section provision of section 2030 and compensation. My lord, that cannot because my lord only one thing. Now, my lord, kindly, if my lord, the Supreme Court judgment, my lord, this is after all, my lord,
You generate revenue, Mr. Shenagupta, law mandates you to pay something, you have to pay that.
yes, I will
If
pay.
you find out your means of generating revenue,
My lord, I am what I am on.
film industry will generate revenue.
I know. My lord,
That's your headache.
that is, my lord, 50 years back, 40 years back, 30 years back now, my lord, they have come up with this application. But my lord, nobody, my lord, I should respect
State should generate revenue to pay them.
my lord, I should respect to the to the honorable division bench. My lord, nobody took into account of the Supreme Court judgment regarding waiver. My lord, kindly see. For the waiver, my lord, constitutional bench after Supreme Court judgment, 5-bench judgment.
Now the position.
No division bench judgment. I have gone through. Well, that is cannot, my lord, what is the logic? I cannot go beyond the judgment. Then my lord is also the cannot be treated can be treated as a parliamentarian. It's contrary to law.
But position, see, compensation is
But
right of the landowner.
But kind of
It's
limited.
your statutory duty to pay them compensation.
Yes, I paid it because this limitation is not a
If
continuation
it was a
one.
money claim, if it was a money claim, Sir Shenagupta, unless they claim within 3 years, then their limitation period is over. So by that principle, delay would defeat equity. But in land acquisition, compensation is your onus, the state's onus. The acquiring body is onus to pay from the day.
But my lord,
That's why you have to pay. There is no
I will
limitation.
pay.
They don't have to claim.
yes.
It's your liability, not their onus.
But my lord, may I put it in another? My lord, waiver, what is the doctrine of waiver? I just put that question. Doctrine of waiver, if it, state cannot use the doctrine of waiver because it is based on public policy, principle of public policy. But if anything is given a right in favor of the particular individual, if the right is not being exercised or was not exercised within a due period of time, or then my lord, it was
Mr. Shenagupta, we will due respect to you. Waiver, there's a yes, we cannot. All of us cannot speak together. Let them finish. Then let them finish. Will then they are still speaking, so let them finish. Ventilated. Now we'll speak. Mr. Shenagupta, there is a difference between acquiescence and waiver. Waiver is a conscious relinquishment of a right. Acquiescence I sit tight. But acquiescence does not apply because if it's your liability, I cannot acquiesce it. Waiver is where I say positively that yes, I know, suppose I take compensation of a particular amount. I say I won't challenge before a court of law. That's waiver. It's a conscious, it's a positive assertion, positive act, conscious relinquishment of a right. I have to be conscious of my right and I have to relinquish that right by a positive act. If that is there, you have a point. If somebody comes and says that I accept this amount as compensation and I will not claim any further amount, then waiver may apply. But if I sit tight, that's acquiescence, which does not apply because it's your liability.
may I give it?
Yes.
It's the aggregate fact they got the compensation.
In this case.
So many cases.
No, here 80% you said.
No, after that award was also passed. They have taken, they kept my.
There is proof that they have taken.
Yes, they have taken. Well, I'll show my supplementary evidence. My supplementary evidence, that is the supplementary. But I have the document that based on the amount
To them.
They are
No, to the state. No,
They
no,
are telling you
That is different.
we haven't received a single party now.
no. Well, kindly come to supplementary affidavit of the state of West Bengal. Well, that is happened on 10th December 2020.
Supplementary affidavit is not the part of the paper.
No, after that, well, the affidavit and supplementary, these are
There is a rejoined supplementary. Yes, got it.
well, kindly see, kindly see. That is the documents, madam, award amount, madam, kindly see. Page 3, start sheet. Is the RS plot number 690 full and 693 part. First, second, three. Page 3.
They are using rejoinder to this.
Yes, they are used, but madam, it doesn't accept it. Accept it thing. Madam, in every case, 80% compensation apart from that.
No, this is where is their signature? You say you have paid. This is the award.
This is the award.
Not paid, mother.
But madam, if they do not, if
If award is paid, then award is made.
madam, kindly consider one. Award is, well, suppose,
Award is final.
madam,
They have to challenge that in section 18 or yes.
section 8. But madam, not in alone in this case. Madam, everything, madam, 80% payment has been in most of the cases. Payment was done. Compensation, not that madam, that just it is written in the act itself. 80% of the compensation.
Here not it. This is the final award.
The final.
Oh.
West Bengal Amendment Act 9, first manner, page paragraph, page 3 manner, when it comes to the heading. Case number 159087, Act 2, proceeding under section 11 of Act 1, 1894. Requiring body Calcutta report. Full lakh 27,870. And then whether they have got the amount, my lord, there is nobody, because my lord, I passed an hour. And my lord, kindly see my report in the form, though it is as a opinion official at that point of time, it was lost. Report in the form of and they were aware of that knowledge. They are kindly see their rejoinder. That under section 3(1)(a) of the Constitution Act was issued. Then my lord, with reconstituted LSA, it would be proper to mention that notice for acquisition under section 4(1) of the West Bengal Act was issued on 27/9/93. It is stated that decision of the honorable full bench of the effect of
So this is the rejoinder to this.
all FD opposition as well as all. Because I filed a report in the form that is treated as an appeal because the original I have lost. So they have used the rejoinder.
What do they say there? They admit
But
that.
can you see that everything they were aware? 27/9/1993, the 4(1)(a) was invoked. And within 3 years, that is there. Within 3 years, if it is not, that's why. Oh, they are not denied.
With regard to 4(1) notice, ma'am.
No, not that. The award.
Yeah, over.
That the award was passed. You have not stated anything.
Because I have stated in my And my lord, report in the.
And also then if they are active, they have a different remedy then, section 18. Not a
My lord, I am not, well, because I have taken the land of some persons. My lord, is my liability or is my
no,
responsibility?
not that. If an award has been passed, then
Yes.
the remedy lies in section 18.
Section 8. Now, they are saying that relying on the larger bench judgment because it is less. That is the matter, the main issue leaves is there. But my lord, in most of the cases, my lord, the award was passed, but my lord, they have challenged afterwards. But my lord, let there be a my lord, they're finding the judicial precedent because so many, but thousands of thousands cases are being pending and one after another order was passed by invoking constitutional. Well, let it be stopped. My lord, so my lord, what I have been humbly beseeching to my lord, that my lord, the ratio, my lord, kindly deliver a judgment and ratio should be, my lord, what will be the effect?
You write it down on a piece of paper, we'll copy it.
My lord,
You are
kindly
telling
see,
our
my lord,
ratio also, but the
you
ratio.
should kindly consider, my lord, the report in the reaffirmation of the report, where I have stated that as because that's why, my lord, I am because my lord, kindly see.
At least leave the ratio to us.
No,
What judgment will
no,
pass, please tell us. But
that I can take the
ratio should be with us.
Well, it is not for my benefit. Well, kindly come to my reaffirmation of the report in the form of a that is stated to be that was stated to be an agreed official because I lost earlier.
Yes.
Well, kindly see that this is the fact.
What is the fact?
Well, kindly see pursuant to the it is stated total quantum of subject line point 3 section paragraph. Total control sensor, the northern portion was requisitioned by the P1 of action for the purpose of construction of variable extent and tower. It is further stated position of the subject was taken on 18/4/1980 has handed over to the authorized person of the requirement on 18/4/1980. Copy of the position certificate is annexed. It is stated the notice dated Sessions case number 37/19 under section 418 was published in the Calcutta 27/9/93. Copy of the. It is stated the title of the petitioner was verified under section 93B of Act on Malad has already seen because they have pointed out in the paper book that 93B was issued. And in terms of land in 1997, it is stated award making compensation amount is also made. It was declared 14/6/2022 to 2002. And the payment notice was issued upon the petitioner responding on 15/11/2020, which was received by them on 23rd/11/2022, but he did not receive the
I
amount.
don't know why you are getting excited. It's your affidavit, not theirs.
Yes, my affidavit. Copy of
Why are you
notice.
getting excited? You say that they have received.
There is no matter denial in the agenda. Matter kindly see the notice I have annexed. That
Did they file an
agenda, yes.
Yeah.
The written was there. Matter kindly see.
let us see the rejoinder?
8, 9 from under section 12 to matter kindly see. Page 4, first page, paragraph 10, page 10 matter kindly see. Of 5 reporting the government. That was not denied.
Let us see.
Their contention was that as per the larger judgment, 418 lapsed. That's why entire affidavit going to lapse and you have to make payment or you can initiate proceeding under section 25. And the honorable single judge has delivered the judgment on the basis. Well, paragraph 10 can page 10 this is the 12/2 notice. For rejoinder, there is nothing. 2002, and they appeal. Oh, before that, manner, they have filed this application. They read application 2001.
Very good.
Kindly come to paragraph, page 10 of my page 10 and 11. That is the notice I have given. In the year 2001,
Yes, notice.
my lord, 14/6/2002, page 10, annexure D. Then this is their signature 11. So, my lord, before that they have filed the report, 2001. I think so. WP number 7845. In the year 2001, because my lord, they didn't, because they filed the application in the year 2001, but my lord, 938, 41, 90B, 31, they were aware of that. Yet the question of waiver is submitted. That is very good. Well, I have got nothing. Yes.
Thank you. BSNL wants to add anything?
No, we didn't challenge that.
That is what we said. The remedy would lie under.
Because that,
You have to,
that's right.
apart from you having paid them.
No,
There.
yes, my lord.
Anything
I
else?
have some instruction from the department.
Yes.
That my lord. My lord, is the position letter.
Yes. No, but new documents we cannot just take like that. If it's not on.
This is the document.
No, for the document we can take on record like this. In an appeal we cannot take on.
Yes, my lord, we have paid the amount also.
Yes, that you have said many times. You have paid the amount to the state.
And we stated our plan with the municipality also.
I have stated that in any of your affidavit.
No, my lord.
So we'll record your submission on that. Then you have taken possession also.
Yes. Yes, my lord.
So you have paid the amount, taken possession, and
Yes.
muted it in your name.
Yes.
ওগুলো নিতে পারবো না দীপঙ্কর নিতে পারবো না মাঝে মাঝে দাঁড়িয়ে চমকে যাচ্ছে
Mutation, my lord.
You will record your submission that you say that you have your stand is that you have taken.
We paid the tax and our assessment number. My lord.
No, but Mr. Mukherjee, this is not an adversarial dispute between you and the state.
Yes.
So that is somewhat immaterial in the present context because but you say the acquisition has
We have
reached
taken
fruition.
the position, we have
Taken
included our name in the
Right.
municipality and we have regularly paid the taxes also.
So that will record that that's your submission. But if they win I mean the appeal is dismissed, then irrespective of that, whatever was passed by the learned single judge will give. So let us hear the response, private response. Yes. Yes, yes. Any liquid. No difficult. After so much arguments. Yes, please.
Hello, I don't know, madam. In the, on 6th April 1988, notice for acquisition under section 3 was given.
Yes.
18 April 1988, position was taken.
All
With
right.
regard to point, my line is only 0.46 decimal.
All right.
Thereafter, now, after 88, my lord, 4A was published on 27 September 1993, madam.
Right.
But no award was passed on 31st March 1995. My submission is the notice therefore under section 4(1) is to lapse after 31st March 1995.
By 31st March 1995, 2 years is the limitation.
2 years, my lord, or 3 years, 7 years.
27/9/1993 was the section 4A notice.
Yes, sir. For a notice?
Isn't it 2 years from the 4(1) notice?
No,
From the requisition notice. The limitation is 2 years from when? The 4(1) notice.
yes, for one notice.
So if the 4(1) notice was on 27th of September 1993,
So it would, sorry, madam, it would expire.
on 26th September 1993.
Yes, 1996, madam.
3 years.
Yes, 3 years come to 26 September 1996.
100
Very well. So notice lapsed
notice that.
by virtue of section 7.
7.
All right.
Thereafter, follow. Now, in the actual portion, but in the meantime, when
Yes.
the acquisition, my land was acquired by virtue of that acquisition with notice. I continuously wrote letter to them, please pay my compensation or release my land because you are doing nothing. 88, since 88, up till 1997, nothing was done. They sat tight towards the matter. Not a single funding was paid, nor my land was. Thereafter, in the year 2000, in the year 1999, I find the application stating there, let them either return back my land, which was requisition, the requisition with my compensation, or uh, compensation should be given to me. So, learned, can you come to page 90, madam? Directed the state level, having heard the at page 91.
Yes.
Mainly concerned.
Please.
Having heard the learned advocate for the respective party, the petition is disposed of by directing the concerned and administrative collector to consider and dispose of the representation of the petition all being annexed in JK to the repetition expeditiously and preferably within a period of 4 months from the date of communication of this order. This order was, this I filed in the year, this order was filed in the year 1999. No matter thereafter, after I served the notice to the notice, even then they did not react to that manner, they didn't do anything. Thereafter, I filed one contempt application. In the contempt application, thereafter, they rose from slumber and asked me to come before them for the purpose of hearing, madam, which is at page 103, madam. And accordingly, in terms of order passed by the honorable judge, hearing took place, madam. It's a big judgment, but I am showing your lordship. I will not come by reading the whole judgment, madam. I will kindly come to, it starts from page 103, madam. Kindly come to page 107, madam. Yeah, read out, please. The prayer of the petitioner has maintained in the annexure IJK of the receipt is justified in regarding for getting requisition compensation up to the date of up to the date as any proceeding is still incomplete. And this was filed by the collector magistrate.
This is page 107, you said?
Yes, sir.
Yes.
107.
Right. Yes, got it. Justified in regarding, yes.
Yes. Thereafter, as such, no award was passed. Within 31st March 1995, the notice of acquisition of the sale land was automatically lapsed with effect from the date of expiry of Act 2, 1958. That the state land stands requisition with effect from March 31st March 1997. Therefore, at present, there is no scope for making payment under Act 1948 as the State Act has been repealed. It is also evident from the produced office, from the produced office, records of special LO, the requiring body, that is the Calcutta telephone, was requested to inform whether they were interested with the land for the purpose for the project. If not, the collector will have to formally restore back the possession of the subject land to the petitioner by serving the requisition order with full requisition compensation on current market price of land as per law. And this is very important. This has been held by the collector. Now, thereafter, on behalf of the requiring body, Mr. A.S. Mandal, if it is submitted written statement of fact which has been taken as part of the proceeding. In the statement, the requisite requiring body has not clarified that the land to be utilized by them in their any project in future, next page, or not the present position of the requisition as average land and their commitment about giving possession back to the landowner and that project is not yet made in accordance with law and they have not taken any proper steps for placement of requisite amount of funds for completion of various proceedings which may cause the relief of the petitioner for getting due and proper compensation. In every aspect of proceeding, the requiring body has tried to pass away their responsibility and liability for proper acquisition of the said land by depriving all landowners, including the petitioner, by compensate by petitioner compensate the due and proper compensation or giving back the possession in accordance with the right title to the petitioner with requisition compensation. With the requisition compensation, considering all the arguments, the statement now 14% coming. Considering all the arguments, the statement and procedure, papers and documents of all concerned parties, the writ application in respect to Minister ICFA, this is to order that the petitioner is entitled to get requisition compensation on at the rate of 6% over market value of the land from the date of possession up to the date of restoration by switching over the in the proceeding under the Amendment Act 1997. And the requiring body is hereby ordered to state either their submission of fresh proposal of acquisition alleged land under the Amendment Act 1997 if they require the same at present or initiate proposal for the degradation of the said plot in accordance with law by giving back for possession of the land to the petitioner within a considerable period after giving proper requisition compensation and the prayers of the petitioner as stated in annexes are hereby allowed. As concerned parties are requested to take necessary measures for immediate relief of the lead petitioner in respect of getting compensation in accordance with law. This order is declared by the undersigned in the presence of all concerned parties. Clear, madam? Yes, pass order in my field, madam. Thereafter, this order was never implemented. Again, I wrote letter. Scores of letter were written, but to no effect. Thereafter, again, I filed one letter application, madam. Being which is at page 121 in the year 2000. That was 1987 or 2000. It came up before lordships, and that was the time. Which is at page 127, madam. Have you lost it?
Yes.
Always this is good. You lost it. The thing was. The order which has been passed by the learned collector House. The authorities are directed to give effect to the said order within 4 weeks from the date of publication of this order. If the Union of India for the purpose for which the acquisition notice was issued and the possession of the property has been taken by the area collector, the area collector is directed to take necessary steps to award money from and in turn to pay the same to the petitioner within the period mentioned herein. If the Union of India is interested, they must deposit the amount within the period mentioned above. Let Xerox copy, certified copy of the order be given to the such and such, such and such. This order was also not compliant. I will come to their opposition later on. In the meantime, what will happen now? This order was passed, it is very important, 15 months, 2001, to give effect to the order passed by the London collector. Thereafter, this notice, performance notice, which is at page 142, madam. Logic file. Notice here was given 0.99 such and such a chunk, including my line also, the same matter. Second paragraph, that is the date of serving the notice on the section. Have you also got it?
Now this is page 142.
142, madam.
Yes.
Performance notice,
Yes. There is the purported section 9 notice.
Yes, sir. The date of serving the notice under section 9CB of the Land Acquisition Act 1999, dated 18/4/2001, madam. This is very important. 1999, thereafter notice of 18/4/2001. If you have any interest in the land or an Calcutta Act for person so interested, you are hereby called upon to appear personally by the agent on 22/5/4/2001, madam. Since at that point of time, the matter was subjugated before the court, but this notice was given, madam. Here I have got some objection with regard to that matter because this was done in a manner only order partner manner. There were three out of three principles of natural justice. Two principles, two principles were maintained, but one principle was not. One principle was maintained, two principles were not maintained. One is to give a chance of fair to respond, and every decision should be based on valid reason, and to allow affected party to understand the decision and seek review if needed, madam. So here is the case of biasness and oligarchical partners. That notice was given. Thereafter, my lord, kindly come to page 144.
Yes.
Here is the preamble. This was published in the Calcutta Gazette on 17th October 2001, where the land, you know, it 145 man. For the provision to subsection 1A of section 23, as you lordship has already, is a third from your lordship, by Mr. Hemuthu was arguing. Of the Principal Act, the following provision has been substituted. In respect of acquisition of the land referred to section 3A, I need to require to read, madam. This will be here, this is important, madam. Now, my lord. My first submission, my lord. It is no, very much. First, I read your opposition. In the opposition, what they're saying, even the opposition of the requiring body, my lord. It is very important to read, my lord. Kindly come to page 150, madam. This is the opposition filed by the requiring body, madam. Respondent number 4 and 5.
This was an opposition in that writ petition. In Justice Pinaki Ghosh's that writ petition.
No, my lord.
Present one. 2001. Sorry.
2001?
Yes.
Yes, sir. No, ma'am. The one which was
Current one. Present.
before, in two order. I mean, yeah, 80 votes.
Yes, yes, that is. Yes.
I need to read the entire portion, ma'am.
No, please.
Yes. This is being affirmed by respondent of 4 and 5 on behalf of this telephone exchange.
This is the BSNL basically.
Basis. And kindly straight to come to page 153, paragraph 11. Madam. First 10 minutes thereafter. On 8th March 2001, a letter was written asking for delivery of the possession of the state land. However, the collector did not deliver the possession. First thing what to keep in mind, the collector, the order which was passed by collector, that was in the year 1999, man.
Yes.
He held in my favor, man, to return back his land or to pay compensation, man. But ignoring that, thereafter I have to come before Justice Pinaki Ghosh. He also passed the order to give effect to the order. Nothing was done. Now, finally, this application was filed, which was heard by Justice Midara Kumar. As you also did.
Yes.
Now, my lord. Paragraph 10. On 8th March 2001, a letter was written asking for delivery of possession of the said land However, the collector did not deliver the possession. A copy of letter dated 8/3/2001 is annexed herewith and marked with the letter C. Letter C is at page 162. Here, my lord,
Yes.
Calcutta telephone is writing to
Hmm.
the Special Land Acquisition Officer. This is to inform you that according to your memo number such and such, and the subject is stated by you, a check of rupees 2,14,755 only has been deposited on 22nd February 2001 towards the final installment of the said total land as moved the success. You are therefore requested to acquire the above stated land permanently or for our department use, setting up a telephone exchange. A formal order may kindly be made for final possession of the said land. This letter was written in the 8th March 2001. Thereafter, kindly again come to Mara and giving trouble to your lordship, Mara.
Hmm.
To 153, Mara.
Yes.
Second 11, Mara. Paragraph 11. On 22nd June 2001, a letter was written by the advocate court of the respondent number 4 and 5 to the land acquisition collector, however, and to the special land acquisition officer general, however, asking for delivery of possession of the said land. However, the land was still not been delivered.
Similar letter, we also see that later at 163.
163.
63.
Yes,
That letter
you
is
think
there.
that is not sufficient.
The state was sitting tight over the land.
Yes, sir.
Even
14 years they enjoyed, madam. 14 years enjoyed, thereafter they passed it away. Taking advantage of 9 city, which doesn't attract, madam. In my case, madam. My case very simple, madam. According to Secretary Madam Rose, 3 years from the date of 1994, that was not done, award was not passed, 4 days goes, madam. Lapsing notice goes on. Now, madam, after the declaring of that,
what would be the position? Then it goes back to the requisition stage. No notice of acquisition under section 4(1)(a).
but madam, first three, requisition converted into acquisition under 4, section
But
4.
that is again invalidated by lapse of 2 years.
Yes,
So therefore it reverts back to the stage of requisition only.
yes, madam.
Only required.
Only required.
As if there was no section 4(1)(a) notice.
True, madam.
Right. Now what would be the effect after introduction of this 9(3)(a) and B?
19 and
Section 9(3)(a) and B in the in Act 1.
Hmm.
So because that deals
that
with
even
48 acquisitions, 48 Act
in
acquisition.
that event, madam, what happened when madam 1997 Act 31st March 1997 goes, madam, then everything goes, madam.
No, simultaneously that was also introduced. But that
No,
was in May,
well, 2 months later,
2
madam.
months later, May.
That is the date, madam,
Yes.
which has to be taken into account by your lordship, madam.
But then if you have to
Because
put that.
that is in the judgment, see a special
Right.
court judgment that has been.
Now suppose that we take that into consideration, then there would be no meaning to this. No effect can be given to 9(3)(a), 9(3)(b) in any case, because that amendment itself came 2 months after the lapse of the
Lapse of
48 Act.
Yes.
So therefore, we have to scrap that from the statute. Virus of that goes then. But 9(3)(a) and 9(3)(b) have never been challenged.
But it was never been challenged, but it was introduced in 1894, not in 1994, which was a temporary act, madam.
No,
Now, I'm
that
saying
you
the
understand.
impact of
But
it.
9(3)(a) and 9(3)(b) are there in the statute, in the LA. So those have to be given effect too. Those are in the statute. If that be so by subsequent, even if it was at the requisition stage, they were sitting tight over the matter. But then they can validate. I mean, they can initiate a proceeding under section 9(3)(a). Here we don't take it as a 9(3)(b) notice, because 9(3)(b) cannot come in, as because the 4(1)(a) notice was gone.
Yes, sir.
It had lapsed.
Yes.
So 9(3)(a) scenario would apply. That there is a requisition, but there is no section 4(1)(a) notice. In that case, 9(3)(a) notice date would be the date on which the market value would be considered, as per 9(3)(a). So that would be the obvious follow. We appreciate your condition that came after 2 months after the lapse.
Yes, my lord.
But even in those cases, even if it came after 2
Because that
months,
was not, sorry, my lord.
no, you're right. I mean, in a sense, it came 2 months after. There was a void in between.
Yes, ma'am.
But even if it came subsequently, it took care of the proceedings which were pending then, even after 2 months. So those 9(3) and 9(3)(b) are valid provisions. They operate in eye of law. They are in the statute book. We cannot read them to be negative.
But
They are there.
But when the temporary provision goes, my lord,
But 9(3)(a) and B has revived, as Mr. Sengupta was saying,
because
not in the sense that he was saying, but those have been revived.
then 4A, when 4A back, later on.
Two situations.
Yes.
One, 3A takes care of a situation or there is no 4(1)(a), only requisition. That has been revived by saying that in those cases, taking 9(3)(a) notice to be the date, award should be passed in your favor. And in 9(3)(b), where there is a valid 4(1)(a), there was a valid 4(1)(a), then that date would be the date of notice of 4(1)(a) would be the date. But that is the law. The virus of the law has not been challenged.
In that special bench also.
Not only no bench has set aside 9(3)(a) and 9(3). Those have been interpreted by several benches, and we go by the special bench, larger bench. That then it has to be treated because the lapse with the lapse of the notice 4(1)(a) goes. We won't accept that contention of Mr. Sengupta. But at the same time, requisition remains that has been revived by 9(3)(a). So we can deem that 9(3)(b) notice to be 9(3)(a), and the market value will be much more than 4(1)(c) date, 9(3)(b) date, 9(3)(a) date.
No, my lord, then in
That is the law.
It is coming under the Act of 1894, Act 1, my lord. Then kindly see, my lord.
West Bengal amendment to that act. Concurrent list. So West Bengal can amend, the states can amend that law.
Yes, ma'am.
So the virus we cannot touch because the provisions are there in the statute. We can at best interpret, and we can interpret in your favor by saying 4(1)(c) notice lapsed. We agree to that for all practical, because it lapsed before the lapse of the statute. If on the date of the when the statute lapsed, it was still pending, valid, then we would apply 9(3)(b). But it had lapsed. Your notice had lapsed. Their notice had lapsed prior to the lapse of the act.
Yes, ma'am.
Therefore, it was already a done deed, done act. So that attained finality. There is no section 4(1)(c) notice, but that requisition is there. Unfortunately, we cannot apply the 2013 Act because this is not a requisition under the 2013, not an acquisition under the 2013. This is acquisition followed, requisition followed by acquisition under
That is there is a provision, ma'am. I will come later on.
Section 24 is very clear. The acquisition under, and there are other judgments also.
My lord, no. Take, my lord, the 1894 Act, my lord.
1894 Act.
Yes, ma'am. It's in 11A, ma'am.
Right.
My submission will be with regard to Section 11.
Mhm.
It is to be read in the context of Section 48 of 1894 Act, ma'am. Because the possession that is taken either under Section 17 or under Section 16. Then 11A comes, ma'am.
Here the award was passed within 2 years after the 2 years after the 9(3)(b) notice.
In the 2002 award was passed, ma'am.
9(3)(b) notice was dated
2002
1
award was passed.
2001. Within that.
That is my margin.
No, that was passed within 2 years as per 11A West Bengal provision.
No, that is that.
Acha, section
So,
48.
at the time, matter was pending substitution before the court. So we refuse to accept that award.
Naturally. Completion of acquisition, not compensation.
No,
Yes, 48 is there. Compensation has to be awarded. No doubt about that. Only doubt is regarding which act would be applicable.
my lord.
It cannot be your land has been acquired and you won't get compensation. That would be an absurd proposition. Definitely not. The governing statute is what we are considering, and the date of
But under section 4A of the 1948, no position is taken, my lord. This is symbolic position, we can say.
possession was the requisition 3-1 notice after that
Symbolic
possession was
position,
taken.
my lord. It can't be deemed to be treated as a position.
No, it was a possession, physical possession by way of requisition. It could not be treated to be vesting under section 4-1 because the vesting was, we don't accept the submission of Mr. Sengupta, which was a very strong submission, but that vesting once vested cannot be divested. But that principle is not applicable in the 48 Act. 48 Act, because the difference of language is in Land Acquisition Act, section 17 read with section 9, that says that and section 11 says 11A says that the land acquisition, that process, the proceeding will lapse. That is the language. Section 11A says proceeding will lapse. So therefore, that was construed by different courts to be that proceedings will lapse, but the compensation has to be paid. Which will not lapse insofar as compensation. Because if there are two situations under LA Act 1.
But my lord,
One is section 4 regular acquisition.
but because the scheme of two acts are altogether different, my lord.
Yes,
48.
we are saying that also. Because why we say this, under LA Act 1, two types of acquisition, one regular, in which case section 16 culminates the vesting.
Yes.
Before that, there is no vesting, and section 11A applies in all regard. If there is no emergency acquisition, emergency possession, and then unless 17.9 is there, 17 read with 9, obviously under 17, unless 17 is there, then it lapses, no acquisition proceeding, everything goes. But if 17 is there, in that case, vesting happens immediately. And Supreme Court has adjudicated that no, vesting cannot be divested. But yes, for the purpose of compensation, it will be done.
That was a different case, my lord.
That was in a different context also. Because here, the Supreme Court took it
You
into
were
consideration.
Supreme Court dealing at the Indore case, my lord. You're dealing with 2013 case.
No, they are also, he draws analogy, but we are not speaking about Indore. In other cases also, Supreme Court had held that yes, for this purpose, if there is the act says so, if there is an emergency acquisition, possession is taken, then vesting happens immediately. Vesting cannot be divested, but the acquisition proceeding won't lapse because for the purpose of compensation, it is deemed to be kept alive. But that was stated because section 11A says the acquisition proceeding will lapse. But in case of 48 Act, not the acquisition proceeding will lapse. In which case we could have held that yes, vesting has happened.
And what I'm trying to impress you, lordship, to save myself from the onslaught of 4A, my lord, I am at 9CD, my lord.
No,
4A lapses.
4.1A says that notice will lapse. If 4.1A said that acquisition proceeding will lapse, then it would go against you because vesting then remains. Acquisition proceeding lapses, vesting remains. The effect will be acquisition will be kept alive by virtue of this LA Act only for the purpose of awarding compensation.
That has already lapsed, my lord. After 3 years,
Notice has that. Notice.
Notice lapsed, my lord.
The effect is there is no notice under 4.1A. But it goes back to it was still requisition and possession is with them.
It has been introduced in 1894 Act, madam. 1894 Act says otherwise, madam. Unless you pay the amount, power to take position. When the power to take position comes, kindly come to specific section 16, madam.
This is not a section 16 case actually.
Not section 16, but what is it? He has drawn the analogy. I am also drawing the analogy.
We'll continue after this. We'll continue.
Item number 3, 4, and 5.
Yes.
My first submission before of the day.
Yes.
In cases where noted under section 4A that the provision of section 93B of the LA Act will not be affected. It under section 4(1)(a), the Act of 1948, madam, cannot continue upon lapse of notice under section 4(1)(a) of the Act. Third, madam, no provision has been made for revival of the lapse notice which stood lapsed on 31st March 1997 for non-compliance or provision of Amendment Act. In the 1996.
Please repeat that. No.
Provision was made under 1996. Amendment was made under 1996
Yes. No, what is the point? Please repeat again. The entire point. Third point.
for non-compliance provision of Amendment Act. Oh, entire man. No provision has been made for revival of the lapse notice which stood lapse on 1997.
Right.
And for non-compliance of provision of Amendment Act 1996.
That is 7th.
Yes, sir. 1996.
Right. 7 was brought in by 1996.
Yes. Fourth point, madam, in all cases, where temporary statute expires, it expires on its own force, madam, without being obliterated by a subsequent legislative. So, in the facts and circumstances of this case, madam, it is a humble submission before a lordship, madam. 9(3)(b) has no application in my case, madam, in view of the question which I have framed before. Because it shuts the door, ma'am.
Right.
No. In regard to my lord, in support of my, I want to say that Lordship has read several times, but even then, I'm to say this.
No, no, taking it.
Reported in EIR 2013 Calcutta. Only was checked for Justice Puru Kyoko Badin and Honorable Justice Puru.
Page 1.
Page, my lord. It will come to page 48, my lord.
48. Paragraph 40.
Sorry, paragraph 40.
Yes.
Perhaps that will kindly come to page paragraph 35. ma'am. Here it has been there. I'm reading. It goes without saying that the Land Acquisition, the Global Amendment Act 1997, deals with the cases of acquisition and acquisition which suffer the consequences of the expiry of a temporary act. The State Act of 1990.
এই পেজটা প্লেন করে দিতে হবে, প্লেন পড়ে যায় কাগজ, ভারী কাগজ হলে প্লেন করে দেয়, একদম ফ্ল্যাট হলে অসুবিধা। সরি, প্লিজ কন্টিনিউ। প্যারাগ্রাফ থেকে goes without saying that LA Act 97.
Yes, saying that it suffered the consequences of the expiry of a temporary act. The State Act of 1987, by incorporating section 9, subsection 3A and 9, subsection 3B, manifestly did not deal with the basis of acquisition which suffered a lapse of the section 7A inserted by 1996 Act. Next paragraph. Dealing 9 3B now. In 9, in subsection 9 3B of 9, the principal act to the second proviso, the following proviso shall be added. Provided also in respect of the acquisition of land made in accordance with the provisions of law in force prior to the coming into force of the Land Acquisition Act 1997, hereinafter referred to as the said Act, and subsequently notice issued and published under subsection 1A of section 4, the West Bengal Land Acquisition Act, which is Act 48, as re-enacted by the West Bengal Acquisition and Acquisition Reenacting Act 1977 but lapsed. Such notice shall be deemed to be valid and the process of admission shall be concluded within the British calendar year 2015 in accordance with the provision of section 3B of the section 1. Thereafter, can we come to paragraph 38 now? The second proviso clearly indicates that the acquisition proceeding referred to therein was one of which initiated on and before 31st March 1997. It could be so initiated only under Act 2 of 48 because the provisions of the State Act 2 of 48 could be taken to be the provision of law in force prior to the coming into force of 1997 Act. Now 41, I am skipping 39. In the second part of the proviso, there is a reference of lapsing. Obviously, the lapsing referred to is a lapsing of acquisition proceeding covered by next paragraph and the next page. Covered by section 4(1) in notification. That should not be a section 4(1) notification after expiry of Act 1948. Section 9 of 1997 also referred to such acquisition notification under Act 2 of 1948. It seems that Act 21 of 2011 and by antedating of the commencement of 1907, the interregnum between the expiry of the 48 Act and the commencement of 97 Act. This is very important. The is sought to be removed and the lapsing of any notification is sought to be validated and reviewed. Interregnum period is 31st March and 2nd May 1997. No, my lord, I am skipping this 42, 43, 44. Kindly come to for the removal of doubt, it is hereby declared that nothing in this subsection 1 of this section shall be construed as prevailing any person claiming compensation such and such with provided to subsection 3B of 9 of the principle as amended by this Act. There is no question of validating a lapse proceeding under 7A of Act 2 of 1940 and by no imagination of 2011 Act having its retrospective effect commencement from the Act 1997 can be said to have devised and validated an acquisition which is lapsed on or before 31st March 1985 by operation of section 7(1) of the 48. In any event, thereafter, ordering motion now. My lord, by. After life of 1948 Act expired on 31st March 1997 and on 2nd May, subsection 3A and 3B of section 1894 was inserted. The object of the amendment was to revive acquisition which was initiated under 48 Act, and to pay compensation, therefore, in terms of 1894. It is not retrospective, but prospective. This is the Harvard submission. That will be fine.
This is in which paragraph?
No, not in paragraph.
Your submission.
Yes, sir.
No, but this proviso will be added. We don't find that proviso. Oh, actually, the Amendment Act.
Yes. 9.
Not there. Paragraph 36 of this judgment.
Yes.
The statutory cited. Added proviso reads as follows.
Yes.
Subsection CB of the second point, the following proviso shall be added. This proviso we don't find it here in our book. Section 2 of Act 21 of 2011 introduces an amendment by adding a proviso to the second proviso. Was it notified? We don't find it in any of the books.
No. This one, this has been just
Para 36 of the judgment. Para 36 of your judgment says Section 2 of Act 21 of 2011 introduces an amendment by adding a proviso to the second proviso. That means a third proviso was added.
Yes, CB.
Of 3B, 9CB. But in the book, we don't find any such third proviso.
Okay.
2011 amendment is not there. Was it given effect? It is not there in any of the LA Acts.
No, right.
You just find out the LA Act, please, Mr. Shanita, find out from LA Act. We don't find any proviso after the second proviso.
Only 11 would
B, there are only two provisos.
No, I think that, sorry to interrupt, I think provided further, I think it is there in the already, but 2nd May 1997, it has already been added.
No,
Why
this, just see paragraph 36 of Field's judgment, paragraph 36.
Section 2 Act of 2011,
There is a second proviso,
2011. just-
2011, by adding a proviso to the second proviso.
Yeah.
And this proviso which has been quoted, we don't find in the Act. No other proviso has been added to the second proviso. 20, in none of the books, LA Acts, we have found this. And this book is of 2025. Well, did this receive assent? We have our doubts in that.
Just a minute, this applies to Act 11. Section 2 Act 21 of 2011.
That Act of 2011, we don't find reference anywhere. The last amendment we know of is 1987 amendment.
Yes.
Yeah.
After that,
2011 amendment, we don't find anywhere.
it means an amendment by adding a provision to the second provision.
We don't find any
Provided also that the land acquisition be made prior to coming to hereafter
British this
one
proviso is not there.
as reenacted by the West Bengal Land Acquisition Act, but last such notice shall be deemed to be valid and the process of agreement shall be concluded within the British calendar 2015 in accordance with subsection provision there.
Do you find this in the book? I never found it in any book. Probably this did not please receive assent.
Maybe. My,
We think that
because otherwise, so that it could be incorporated in the.
could have been in at least any of the books.
And at least.
What is
the
your
Latest
pub-
Act also.
Both the publications is not there.
No.
I've never come across this proviso at all.
Yes, I.
And you do this matters regularly.
But I will check it up.
None of the books is there.
None of the.
You
You will have
have
to check
it.
it up whether assent was given or if the assent was not given, then.
You are in a position to check up Mr. Shangupta because of your
Yes.
because you're on the state.
Because I can come across.
Yes, you have an access to this.
Yes.
We don't think this ever received assent. Otherwise, it would have been in some some of the books.
In that manner, don't consider it that.
Even otherwise, we take your point. We accept it.
Right, man. This is very also not common.
Never. You have done so many cases. Mr. Shangupta has done so many.
Because if I suppose it
This
is
is
there,
done.
then it will.
Even if we consider this,
Yes.
then the interpretation is that this lapse is regarding lapse of process of acquisition, which does not affect us here.
Yes.
No.
Because we are speaking about the lapse of the notice.
But I will.
No, Doctor.
So please check up. No, don't do it.
No, ठीक है.
Other,
तो देखिए आप.
Yes.
हाँ, बड़ा और
I
लाइट.
think what is it?
But the other proposition, para 35 proposition and the rest of the propositions should take into consideration of this judgment. That Land Acquisition Act 1997 dealt with cases of requisition and acquisition. Said Act of 97 by incorporating 93A and B manifestly did not deal with the basis of acquisition which suffered a lapse under 7A. That proposition still remains on the basis of the present second proviso also.
So the question is that really that has been also kind of consider that also. Section 93B.
Yes.
Notice was issued under any act in 1937. Only on about 18 April 2001.
Yes.
An award was declared only about 14 June 2002. Not about on. And the submission made by me, my learned friend,
Yes.
the award has been passed and money has been given, not a single person who have received my award.
Money might not have been given, but if an award is passed, your remedy lies elsewhere.
Section 8.
ठीक है, जमीन.
Obviously, you know.
You make some external mind. That will be.
Mr. Shangupta has this habit of disturbing. You please check him. You are senior to him, please check him.
Good score, man. Nice guy.
No, we dispute that.
Then I've got nothing issue.
So we also have not nothing against him, but he has this habit, intentionally disturbing the other side. He's trying to break your rhythm. Please don't lose your rhythm.
No, it is just the code to idea of the region.
You will not lose your rhythm. So
To clear ambiguity, man. Can you clear the ambiguity? We have to worship to idea of the region.
So your first point is that in cases where notice lapses under 7A, 9.3b won't apply.
No.
It has already lapsed. We agree with you in principle.
C and B both, man.
Now, 3A, you have to argue on that. The 3B does not apply, obviously, because the notice lapse. Language of 7A is notice will lapse. So there is no valid notice under section 4.1. But still the requisition process is there. Why shouldn't A apply? 9.3A apply. A speak as the three judge bench also held in our court, which was cited by Mr. Shemu. Special. That special bench judgment you have to take note of. There it was ultimately construed that there is no notice. Then if there is no notice, then 3A applies, 9.3A applies. And accordingly,
notice lapse, man.
4A notice lapse.
Yes.
So the position will be that there is no section 4.1 in notice.
Yes.
9.3A speaks of a situation where there is no section 4.1 in notice, but a requisition has happened.
But when, man? Question arises when?
No, requisition does not get invalidated. Two steps, requisition under section 3, you know that.
And
So,
four.
and 4 acquisition. So the acquisition notice gets lapsed. There is no acquisition notice under law. But the requisition, section 3, requisition position, those remain. It reverts back to that stage. If it goes back to that stage, then why shouldn't 938 not apply? 938 takes care of such a situation where it says that a requisition has been done, but by necessary implication, no section 4.1 notice is there. Because 938 language is that collector shall also serve a notice to the same effect on all such persons to be entitled to act so interested the possession whereof has already been taken on requisition under section 3 as reenacted, and in every such case this section shall be deemed to have been complied.
But my condition is
Only requisition.
this came into effect from 1997, my lord.
May 1997.
It is May 1997.
And that act expired, spent its force in March.
Yeah.
31st March.
Yeah.
So in the interregnum, but this act, as held in the judgment cited by you also, the 9 3A and 3B revalidate the previous portions. The purpose of 9 3A and B is that revalidating because that is also held there, that the retroactive effect is intended to, take care of the interregnum. That language is used. Interregnum between March and 31st March and 2nd March. That interregnum has been thought to be overcome by 9 3A and 3B by giving effect from before that. Because the language of 3 and 3B is that any notice under the 48 Act. Any requisition proceeding under the 48 Act.
But we did not 7, my lord. 3 has to already last month. 3 has expired.
3A. We are speaking of 3A. 3B does not come. Because there is no notice. Notice has that. But conspicuously 7A does not say that the the requisition will lapse.
No.
There cannot be any lapse of requisition as such. Or that the section 3 notice lapses. Even if that was said, then requisition would also go. And they had to give back the land. So apparently the only plausible, anyway, you complete your arguments then. Your second ground was vesting under section 4.1A can't continue after lapse.
Yes,
By lapse you meant under 7A or lapse of the statute.
lapse of the statute.
This in any event does not come in your case, because in your case by 7A during pendency of the statute itself it got lapsed.
31st March 1997.
31st March. So therefore, if this was a case that 2 years had not elapsed and it was continuing, then you could argue this. But the second point is vesting under section 4.1A can't continue after the extinction of the statute. That is not German, because before the extinction of the statute, it lapsed by 7. So there is no question of the section 4.1A notice continue by virtue of section 7A. And third ground taken by is no provision for revival of notice which lapsed on 31st March 97 for non-compliance of Amendment Act. We agree also there, because this is related to the first point, that once notice lapses, 9.3B cannot apply, and also there is the provision for revival of that. Last count is in all cases where temporary statute expires, it expires on its own force and not obliterated by subsequent legislation. True, not that. It spent its force on 31st March. But by virtue of introduction of 93A and 93B by the 1997 amendment to the LA Act, that has been given a new lease of life in West Bengal.
But legislation is hiding from that aspect. Legislation is hiding from that aspect.
3A is there. 3A says that in such a case, in case of a requisition under section 3 of the 48 Act, some provisions will not be applicable. Yes, let us come to 3A once. the collector shall also serve notice to the same effect on the such persons interested in any land and such, the possession whereof has been taken on requisition under section 3. So this contemplates that the collector may serve a notice under 9(3)(a) in a case where requisition has been done under section 3 of the 48 Act. And in every such case, 4, 5, 5(a), 6, 7, 8 shall be deemed to have been complied, and provided that the date of notice under this subsection shall be the date of reference for the purpose of determining the value of such land under this Act. So this contemplates a fresh notice. Even supposing the 1948 Act was still in force, it had not lapsed, then also why shouldn't this principle be applicable? Because the requisition remains under section 3, that is never obliterated. So 4(1)(a) notice, it lapses. Then they have to issue a fresh 4(1)(a) notice. They would have to issue if the Act was there. Instead of 4(1)(a), now it's substituted by 9(3)(a) notice. Effect is the same. But the intention is to give the most current market value to the land user, obviously. Therefore, if only requisition, then 9(3)(a) notice date would be the date of when the market value has to be ascertained.
That's about my own, but like, next limb of submission will be matter. There was a continuous persuasion with regard to the matter.
On your end. Yes.
14 years. So, right to fair compensation as attraction.
How?
If that,
How?
because it says,
See section 24.
Section
114 repeals LA Act.
Yes.
114 repeals LA Act. And please see section 24. Under which provision you come. It starts with in an acquisition under the LA Act. If it spoke of any acquisition, you could have understood. Then the language would have been in case of any acquisition under any act, any statute, then the rest. Please see the language. 2013 Act. 2013 Act down. Yeah, right. Right. Yes. Surprise নেই বলে হয়ে গেলে তারপর কি চরম সারপ্রাইজ। থ্যাংক ইউ। Clear language. Notwithstanding anything contained in this act, in any case of land acquisition proceedings, then initiated under the Land Acquisition Act 89. That's a precondition. And there are judgments which have not been cited by Mr. Sengupta, but he cited in some other matter. That was in respect of the Land Development and Planning Act 1948. Now, in that connection, there is a judgment of the Supreme Court. I'm very bad at remembering these citations. That no other statute would be covered by right to compensation. Only if the proceeding is the acquisition is under Land Acquisition Act, then this provision applies.
Yes.
And it's obvious from the provision itself, not in respect of acquisition under any other act.
That is Bangalore Development.
Bangalore Development of right. Have you got the citation, Mr.
Yes, 2022 14 SCC
17?
173. 2022
Yes.
14 SCC 173.
You've got it at your fingertips.
Well, because I did not swear knows that, and above all, that
Absolutely.
LDP Act still is there because 19 this
LDP Act
Act
is
is important. That's why. But there,
Oh, understood.
yes, that
There is no
ratio is
question.
there. Ratio is there.
But that
That-
is there. That.
and initiation manner, two division bench judgment have said. But at that point of time, this judgment has not come. The constitutional bench judgment has this solved.
You would have been in a better position if we were at the Supreme Court, or if you take our judgment, whatever judgment we pass, because we make it clear till now, subject to reply given by Mr. Sengupta. In our view, this 9(3)(b) notice was a wrong caption will deem that, otherwise you will not get your compensation at all. The requisition will remain forever. There is no 1948 Act now. They cannot issue any notice there. And in this case, the 93B notice was issued. We'll deem that, and award has been passed. We'll deem that to be, we can deem that to be a notice under section 93A. And since an award has been passed, your remedy lies in section 15, section 80 reference. We'll have to say that. But this notice lapsed. 93B is not applicable. But the 93A is applicable, the vesting limit. So we'll give you liberty to file a challenge under section 18 of the LA Act.
Don't think you over here.
Don't?
Can you find the judgment? Don't think over. It will take another 5 years, madam. Already she's 75 years old now.
We would have loved to pass an order at the current rates. We are being very candid. Because your land users, you are at the suffering end. Your client is at the suffering end. But we don't have 142, Article 142. That's why we said that if you prefer, we'll pass that judgment. You can take that judgment up in Supreme Court, and under 142, if the Supreme Court grants that relief, then
Another 5 years, madam.
more than 5 years, going by the present standards. Circulars are issued to us, to the High Courts, but
What I'm saying is, for fix up a date. On that, from that date, they will.
Yes, I agree. I'm agreeing that because my lord, 9 GB the date.
Give me the date, then kindly fix that date, madam.
But kindly consider.
Because good thing you over there now.
The Supreme Court
It will
judgment.
take another 5 years, saying I will not follow you. But I will remain on what I'm on.
you are absolutely right.
My lord, here, my lord, that lateral bench was challenged by the state. Although it was dismissed, but the ordering portion, because this is a civil appeal.
That is 142.
No 142. That is why. That's why this is not. That's no sir. My lord, kindly see.
Act says otherwise.
My lord, kindly see.
Act is very specific. Provided that the date of notice under this subsection shall be the date of reference for the purpose of determining the value of such land under this act. How can you overcome this?
My lord, kindly consider one thing. My lord,
Even High Court did not do that.
Well,
Supreme Court did that.
yes, Supreme Court can. My lord, kindly consider. In all those cases where 142 of Article 142 of the Constitution of India was invoked by the Honorable Apex Court, there is a clear writing on that. Because in my lord, I have come across various judgments so far. I used to do the
Not in all cases.
marriage and divorce cases.
Yes, yes, 142.
142, it was clearly mentioned. But my lord, here,
Not in all cases. Not in all cases.
but
Not in all cases.
142, my lord,
142 does not provide that the Supreme Court has to mention it is passed under 142. Under 142, Supreme Court is vested with
for
the
the ends of justice.
and for the ends of justice, it is done often Supreme Court.
But not, but there is a judgment.
Supreme Court in many cases does not say that I am doing it under 142. Matrimonial matters that because that ground is not available. It's
I have
being
seen,
introduced.
I have seen recent Supreme Court judgment, but I am not.
Yes, yes.
I'm not agreeing because recently judgment I have come. DFT.
Ringovati dealt with Rakesh Raman. Rakesh Raman 141 was resorted.
That cannot be the.
But Rakesh Raman did not say I am resorting to 141. That has created a problem. We are resolving it, untying the knots.
Because 141 is the precedent, but 142 is not a
Supreme
precedent.
Court did not write and putting
Yes.
this under 141 or 142.
Yes.
For ends of justice, Supreme Court has the
Because I
power.
have this.
See, you see the tenor of the Supreme Court judgment in your.
Kindly, I am astonished. Well, kindly see.
Don't be astonished. The Supreme Court has power under 142.
That doesn't
In other cases also-
contrary to law. There is a judgment.
Only with regard to that matter.
Yes, yes.
Well,
Only
there-
in regard to that matter,
I
which will
can
be binding.
show the judgment of the Honorable Apex Court where it has been held. Even 142, he has to, my lord, fulfill or comply with the rigors of rule of law. I can show that judgment.
Let us see that portion.
But kindly see, well, the second year, having regard to the entirety of the situation, well, that is state of government, that is the next.
Acha, next one.
After, well, kindly come to press 1,
Yes,
2,
yes, yes,
3,
having regard.
1, 2, 3, 4, then another judgment. So
Have you given a copy to your letter friend? This is-
I will hand over.
If you have an extra copy, please do.
Yes, I will hand. There are so many judgments who have been cited by the other side. That is the response therein. Well, that is 4, paragraph 4, page 4. Well, because I have to, my lord,
Just let us see these appellants have acquired land of the respondent for public purpose.
dealing
That there is some dispute whether the award covers the entire land which has been acquired. There is further dispute as to the date with reference
market value should have been determined. Here, madam, very see Supreme Court.
having regard to the entirety of the situation. The High Court may
It's
impute a
very different cases.
determination of market value.
4 different cases.
We affirm the same view.
18th was 1999. So why not fix that?
Giving the acquisition.
Give me.
How can you deem under which provision of law?
Well, Supreme Court has because it is a because kind of
No. High Court determined directed determination of market value as on 18/3/99.
Well, may I explain?
No, that was the date of the notice.
Notice under section 93.
Yeah.
Well, kindly consider one thing. Well, here Supreme Court on the kindly see dismissing the appeal, but reaffirm. Well, kindly say, since we do not find any ground to interfere with the impugned order, while dismissing the appeal, we direct that in terms of the impugned judgment, determination of market value as on 18th be made within 2 months. So it is the cutoff date. Supreme Court fixed it.
No, 18/3/99 that was held by the High Court. That is affirmed by the Supreme Court.
That is the
That was the date of the notice.
date of the notice.
Supreme Court is not fixing any other date.
93 what my
That is what we in any event have to do. 93B is the date of the 93B will treat as 9A, 3A. And here also Supreme Court did not hold that
Yes.
some other date.
And madam, not only
But in 2013, under the 2013 Act, in one of the judgments cited before us, we saw Supreme Court had arbitrarily fixed a date. Justice Gawai's judgment.
yes.
You had cited it. Justice Gawai's judgment. Supreme Court, but there it was clearly under 140. But in view of the sufferings of the land loser, such and such,
Fix it. Supreme Court fixed the date. That date of determination should be counted from this.
well, we are not passing judgment right now.
Yes.
We'll have to consider all these judgments. So,
And madam, only one thing, madam, kindly take into account.
yes.
And again at the cost of repetition, because 93B, it is the vesting revised. Madam, my lord can say whatever my lord I am not. Well, I am not that. But madam, my submission would be
Yes.
that by a dint of legislation, the vesting remains. That is
Yes. Very well. Third learned counsel for the parties. Pushtak. Hearing is concluded and the matter is reserved for them. Thank you.
and my lord, the parliamentary of submission, my lord, kindly take. Even my lord can have the power. It is not binding. If it is not, it is implied the principle of parliamentary.
Special method.
Yes.
Judgment, I power. Sir, there is no such. My lord,
If you are saying, I will definitely record it.
I have not come across with anything that High Court is powerless. High Court is powerless to do or to see whether it is implied by principle of parliamentary or not. There is no such judge. Yes. Larger bench is fine. Yes, I appreciate.
Then how can you take it?
If
But
it is hit by the principle of parliamentary, totally contrary to the statute. Statute says that vesting remains.
But we agree with the larger bench judgment's view.
That's why, madam, kindly take.
Oh, your argument.
Yeah.
I want to see some photographs, madam, for nostalgia. They are saying
Better send photographs of Mr. Shinmuthu to your client. Yes, photograph
Alright.
regarding what? Photograph
there is question of a land. Although they are saying land has been taken acquisition, they have bid such and such thing. Although enclosures have been put the land and they makeshift room and all these things, madam, can you see these are
to understand by the connectivity of the BSNL internet. Someday your learned friend appearing for the BSNL will suffer for that internet connection. These are the reasons.
Promise.
BSNL is the only service provider where for regarding complaints for this online server, you have to go physically there and make the complaint.
Yes. Absolutely, my lord.
Probably only service provider in the world, but the
And
Lord cannot do anything on that count.
My lord, I will come up with another 4 application. BSNL is the requiring.
No, but we cannot improve the connectivity by
100.
Thanks. No problem. কিছু করো। হ্যাঁ, হাত চিপটিও না। তো 7 দিন আসবে।
Item number 5.
You have to start today. Yes. Last chance was given.
Yes, Your Lordship.
Second last chance was given also.
Yes.
Yes, Your Lordship.
Now start. You are confident enough. You can easily start. You are for the state. Private. Oh, state is the applicant. Sorry. Yes. You are Mr. Shaha. Yes. You had just been started.
Yes, Your Lordship.
Barely started. You can
Barely.
place that, please. Yes.
Your Lordship, may I take the order on the channel? 242 of the paper book. Your Lordship, volume 3.
Right. That's
This pertaining to the piece of change in management
yes.
in usual course, Your Lordship. The new Kenilworth Hotel was initially incorporated in 1970 as a private limited company.
Not 1980.
No, 1970, 29 April 1970. 29th April 1970. It was incorporated.
Incorporated, yes. As a private
As a,
limited company.
private limited company.
Yes.
Thereafter, Your Lordship, due to the application of section 43A1B of the 1956 Act, it was transferred to a public limited company.
When? Not there.
In the year 19. Around the 1990s, 95 years. And subsequently thereafter, in 2002, it again was converted into a private limited company.
Again, private limited.
Yes, Your Lordship, in 2002.
All right.
In the meantime, there had been certain changes in the management and the board of directors. 3 directors were changed and introduced.
1981, family member was introduced.
Yes, Your Lordship.
82 to 88, sons of the existing directors joined the board.
Yes, Your Lordship.
And one Vasant Goswami, not family member, introduced in 1998.
Yes, Your Lordship. Thereafter,
So as of today, it's a private limited company again.
as of today, it's a private limited company.
Very well.
And may I place the order?
Yes.
Their main challenge was the exemption provided under Rule 5(1) of the West Bengal Excise Change in Management Rules of 2009.
Yes.
The regulation of 2009 says the regulation of 2009 deals with the procedure for application
for change in management.
You're reading from the judgment or
No, Your Lordship. And
this is your
indicates. The clause 4 indicates the procedure for different organizations, be it private limited
yes. The
company.
rules are at
public-
page 161.
Yes, Your Lordship.
These are the rules. No,
No,
no.
160.
161.
Yes, Your Lordship. 161.
Wait a minute. Yes.
May I please the regulation before I go into the
Relevant portions. Yes.
relevant portion?
Yes, absolutely.
Clause 4 says the procedure for application of change in management. Your Lordship, in clause 1 states the application, subclause 1. The application for change in management and an exercise license may be made to the collector in whose jurisdiction the site is situated. No application for change in management of a license shall be considered unless it is accompanied by an appropriate receipt treasury challan showing payment of non-refundable application fees similar to one application for grant of new excise license in the same category, in the same location area.
Only 5D was challenged.
Yes, Your Lordship.
5 is a 5.
1D.
That's a proviso to rule 5. D.
I can indicate, Your Lordship.
That's a page 1.
Clause D of the proviso to rule 5.
Yes, Your
Clause D.
Yes, Your Lordship.
Clause D says on the death of director also that will be taken to be a change of management.
Your
This
Lordship,
is
may
patently
payment of fee.
irrational.
No, Your Lordship. This is not the point.
Someone dies
The
and
exception. The exception, the fees will not be applicable in case of death of the director.
Acha.
That is it. Your Lordship, may I read?
Okay.
5.1. After getting approval of the state government or the excise commissioner, as the case may be, the collector shall allow change in management of a license after realizing 1.5 times the initial grant is similar to one applicable for grant of a new license, new excise license of the same category, of the same location. The collector shall also record the change in the concerned license, provided that no initial grant fees of license shall be payable for change in management in case of. Now it comes to D, which is death of directors in case of a private limited company, and E, death or change in management in usual course of business of a public limited company incorporated under the Companies Act 1956. This was the challenge of the hotel, the New Kenilworth Hotel, indicating that when in case of the public limited companies, the criteria is death or change in management in usual course of business, the same criteria should have been applied in case of a private limited company as well. They could not, the regulation could not have made a distinction between the private limited company and public limited company with regard to the change in management in usual course of business.
But they are now a private limited company.
Yes, Your Lordship.
So they will be benefited by this discussion.
No, Your Lordship. They in that case.
Oh, it's a change of
it
management,
was
not
change in management.
It's an exception.
It's an exception.
All right.
Lordship, in private limited company, this exemption will be applicable only in case of death of.
So, what is the rationale behind this? There has to be an intelligible criterion as well.
Yes, I mean, I submit, Your Lordship.
Differential.
Private limited company and public limited company are absolutely two different categories of companies with different criteria, regulations, and formation and rules and regulations pertaining to be it board of directors, be it management, or the shareholding, Your Lordship.
All right.
Private limited company, especially in the case of the petitioners, is a small family company. Your Lordship, within where the directors or the management is strictly within the company. Your Lordship, in public limited company, the change in management, there are the, Your Lordship, may I submit this? The change in management has to be read in as a whole, Your Lordship. The change in management in usual course of business, not only change in management. In public limited company, there is a scope of change in management in usual course of business. But in private limited company, the change in management in usual course of business is only in case of death of the director. In other situations, the change in management is a choice or discretion of the directors. It's not a usual course of business.
You could have put in usual course of business.
Yes, Your
In
Lordship.
D
It has been mentioned, Your Lordship.
In D also you could have put in the death of directors or change in management in
There
usual
is no, in private limited company,
no
there is no scope of change of
You are saying this on the basis of
course of business.
saying this on the basis of the Companies Act.
Yes, Your Lordship, actually.
Cite the relevant provisions.
Lordship.
56th Act will look into that.
Your Lordship, may I indicate in case of a public limited company, the direct appointment of directors are fixed, Your Lordship. The tenure of the directors are fixed
Public.
in a public limited company.
Tenure of directors are fixed, yes.
They have a mandatory retirement by rotation, eligibility of reappointment. These are all there. But in case of a private limited company, the change is restricted to the clause of the Articles of Association, Your Lordship. Your Lordship, in the Article of Association or the memorandum of the Calcutta Hotel, it has been specifically said the office of the director shall be vacated only under any of the circumstances enumerated in section 283 of the Companies Act or and in usual course would mean in a private limited company, usual course would mean only upon death of the director or any specific ineligibility of the director which has been seen, Your Lordship.
And in case of public limited?
Lordship, public limited company, Your Lordship, there is a fixing of tenure of directors, mandatory retirement or rotation, the eligibility of reappointment of such directors. Those are all indicated in a public limited company.
There cannot be a removal of directors in a private limited company.
Yes, Your Lordship. There can be a removal of directors in a private limited company, Your Lordship.
There cannot be a tenure of a director in a private.
Your Lordship, that is till they are particularly removed or till the death of the director, Your Lordship. But that cannot be, in my humble submission consideration, Your Lordship, that cannot be considered as a change in director in usual course of business.
No, can't a private limited company in their articles or memorandum of association articles of association or memorandum put in a clause that there will be a tenure of directors? Is there any bar?
No, Your Lordship, but-
Whatever a public limited company can do, that can be done by a private limited company also. Why not?
But the Your Lordship, the public limited company and private limited company are works or conducts its business in two different genre category altogether, Your Lordship.
Why?
The control of the in a private limited company, the control of the directors over the company is supreme, Your Lordship. If there is a change in director, this is that change will be discretionary and on purpose. It cannot be termed as change of directors in usual course of business, Your Lordship. There can be change, but that change will tantamount to the change in control of the company. That will be discretionary. But here the regulation indicates change in change in management in usual course of business. If it would have been a mere change in management,
You say in a private limited company there is no scope of
change in
changing the
management,
usual course of
usual course of business. That will be upon the death of the director, another director comes in.
But
That
they
is
may
the
be
usual
within the
course.
family. They may be within the family. That will also be usual course of business.
You know, that will be discretionary. If someone wishes to step down from the directorship,
What is the difficulty in discussion? I mean,
that will be the
if it
change
remains in the
management.
family,
Absolutely, but that will be the change in the absolute control over the. It's a small family, private companies are mostly.
suppose it's a 5-member family, there are 3 of them are directors. The fourth one comes in place of the third, or
That will be discretionary
within the family.
within the family, but that will be discretionary here. Not an usual course of business.
The usual course of business is defined in the Companies Act or mentioned in the Companies Act. What do you mean by usual course of business in the rule? Has that been defined in the rules?
No, Your Lordship.
So what is usual course of business? What is there cannot be any change of management in usual course of business.
Usual course of business would in a
You
public
said the
limited
retirement
company
age or
would
tenure.
be
Tenure or retirement age.
tenure or retirement age in a public limited company would be.
But there is no such concept in a private limited company, tenure or retirement. In a private limited company also there can be a retirement of a director or
That has not been indicated. There nowhere indicated in the Companies Act. So I'm a little handicapped with the act, but also right now. That is the case.
Mr. Chaudhary, you argue for them also. What could be their best case?
I will indicate
On company law.
On
On company law.
I will indicate what was there because of Honorable First Court. The entire basis, what they were trying to argue was that because there is a fundamental difference in private law relating to private limited companies and public limited companies, in the sense that the restrictions for a public limited company for compliance is much more stringent than that of private limited company. Therefore, this is there. But this argument has been negated by the learned First Court on the ground that the distinction in company law is not at all relevant for the purpose of ascertaining whether the reasonable criteria, which is the test. Because whether what is the purpose here? This is the 2009 excise law. Now, whether the excise law has been framed so that whether the government is not deprived of its revenue. So, what is the law? That each time, so far as companies or association of persons are concerned, each time there is whether the crucial word is, I read the entirety of that, whether there is a change in membership, that is the shareholding is getting transferred. In other words, you are keeping the company intact, there is a change in membership, shareholding transfer, you have to inform. Any change in directorship, you have to inform.
As per the rules.
As per the rules. Now, here the exception is that, and what is the consequence? Then the collector will grant you permission by charging 1.5 times of the initial license fee. So, as if, because the rule is saying that if there is a change in membership, the original excise license granted will come to an end. So, it will be as if somebody is applying new
So 1.5 times of that. This is, my lord, the general law. So what is the mischief? My lord, in all interpretation, we say that so that the state gets the maximum revenue, and on this legal jargon, the state will not be deprived of revenue. If today I keep XYZ Limited, I give my entire shareholdings to her. In effect, she comes in management of the company, or her company comes in management. Then effectively, it's a new license. Instead of taking a new license, you are doing. So this is what they are trying to prevent. Now, the entire law, it treats in private limited company and public limited company at par. You will have to inform. Now, so far as the 2005, my lord, made no such distinction. For instance, my learned friend fairly stated, today, if a director dies, in case of a private limited company, in place of death of a director, I bring in a new director, I have to pay 1.5 times. In case of a public limited company, because the new director is coming in consequent to death. No change in shareholding. Over here, my lord, Kenilworth company has been with, my lord, these management, my lord, for the last 40 years. It's a family-owned company. Father has died, son has come in, mother has come in. That's all. In the shareholding, that is also known. Change of directors, the present problem, while we were saddled with the demand, we had to put in that money and then fight this case.
But death of director is protected under this exception.
Death is protected, but I can't appoint anybody in his place. Death of director is a common for both private and for public.
Yes.
Moment I bring in somebody in place of, and how do I comply with the minimum requirement? X dies. Instead of X, Y comes in. Moment Y comes in, change in management, not in usual course. That is not there. For public
Only the factor of death is not a change in management.
Death I
So
don't.
there are 5 directors, one dies, no change of management. 4 remain.
4
But if
directors.
you bring in another 5,
Correct. Now when a 4 director, 1 dies, no change in management. Now for the minimum of 3, if I bring in my 3 directors, 1 dies, I bring in somebody new, change in management.
No, Your Lordship, that is subject to correction, Your Lordship. One dies, there is a 3 directors, one dies, bring in one, third one, there is no change, Your
That,
Lordship.
let my learned friend show that law. This is the anomaly. So
No.
my lord, if
The
for one,
difficulty with
if for one director, no, then if it is Y, my lord, why apply the law when from 6 it reduces to 5, they will ask for money. From 3, if it becomes 2, they will not. My lord, that can't be a.
Mr. Chaudhary, is the submission correct that for a private limited company there is no scope for change in usual course of business, change of management?
Change in usual, my lord, today, my lord,
First of all, we don't know the meaning of
my
usual
lord,
course.
Lordship will not find, so far as removal of directors are concerned, both under the 56 Act and 2013 Act.
Yes.
Lordship will not find, will not any separate distinction so far as removal is concerned. Directors are all, my lord, so far as the 1956 Act is concerned, 284, my lord, it is absolutely the same. '56 Act, Lordship have it. You know, Lordship will see 284. I'm sorry, my lord, 283.
283. Yes.
Vacation of office by a director, 283. Office of a director shall become vacant. Well, then from A to L, Lordship will find there are a lot of things. A is he is removed by 284 and all that. And then the only addition for private limited company, Lordship will find is in subsection 3 of 283. A private limited company, a private company which is not a subsidiary of a public company may by its articles provide office of a director shall be vacated on any grounds in addition to those specified in subsection 1. So a private limited company may have additional grounds. But that doesn't matter. Here, matter the test is to qualify that you have a reasonable
Nexus between the purpose
Correct.
and the.
What is the purpose? The purpose is to ensure. Now, may I kindly see the rule. My lord, if Lordship reads from.
If there's a change of management, then a new set comes in.
Well,
It's like as new license.
Lord, that is very clear if Lordship reads the entirety. I'll just show my lord from sub-rule 2. My lord, kindly take the 2009 rules.
Yes.
Kindly come to rule 4, sub-rule 2. My lord, rule 4 is procedure for application of change in management.
Yes.
Then my lord, kindly comes to Rule 2, sub-rule 2. Rule 4, sub-rule 2. At page 162 it should. A license granted under the Bengal Excise Act 1909 to a company, I am ignoring society, cooperative society or a firm. This is very important. Shall stand determined on any change of, kindly notes the expression, change in membership of the company. So when is the license getting determined? Any change in shareholding, even one share goes here to there, determined. But then, unless cooperative partnership so and so, unless in case of a company, so an exception has been carved out for a company, prior approval of the state government, and in case of partnership firm, a society or cooperative, prior permission of the collector is obtained. So even if there is a change in shareholding, or transmission of shares also, that can happen, change in shareholding from father, son is getting. So ordinarily it is coming to an end, but then you have to take prior approval, you indicate the reason, no, it is only transmission, that is why it is happening, so it will not be. Then next, subject to the above requirement, any change in management, so the cardinal rule is change in shareholding, it has nothing to do with that, because if I and my shareholders remain constant, at my wish I can bring in X, Y, Z, ABC as the directors. There may be change in management as such, but there is no change in shareholding. Subject to the above requirement, any change in management in a company registered under the Companies Act 1956 or in any change of board of directors. Now, two things are coming: change in management or any change of board in directors. So let us assume for a time being both are synonymous, because either or. Now kindly see, both private or public. So this is applying to both. Membership case of society, we are not concerned, shall be brought to the notice of the collector within a period of 7 days with application for regularization of the same, along with a non-refundable application fee similar to one applicable for grant of a new excise license of the same category in the same local area. Now, Lordship will see in these two provisions, that is subsection sub-rule 2, it is the main criteria is change in membership. The next paragraph is saying change in management. So change in management arising out of change in membership. That is the only way you can read. So for both public and private, you will bring it to the notice of the collector. Then, my lord, I read the proviso. Provided further that in case of change in management from a firm, society, cooperative society to a company which is registered under the Companies Act, or from a private limited company to a public limited company and vice versa, and in case where there has been a takeover or acquisition or amalgamation or merger of a private or public limited company holding an excise license with another company registered under the Companies Act, the management so changed, subject to the requirement of prior approval mentioned above, bring the matter to the notice of the collector within a period of 7 days with application for regularization of the same, along with a refundable application fee similar to one applicable for grant of a new excise license of the same category in the local. That is, 1.5 times what you would have paid there. So all the criteria which is talking of this, firstly, irrespective of public or private, any change in board of directors or shareholding, you bring it to the notice of the collector. And then, so far as company is concerned, you can continue if you have the permission. So, what would constitute, because the rule does not define change in management. They tried to do that later after the writ petition was filed, but that has been negated. I will come to that. Now, in this background, if Lordship now comes to Rule 5, payment for fees in change in management. So 4 says the broad criteria, the charging provision. Because the mischief of the statute or the rule is the state will earn maximum revenue and the state will ensure that there is no change in the ownership of the company. The idea is no change in the ownership of the company. That is so that the state is not deprived of the revenue. Somebody who will apply for
a new set of people come and they.
Correct. Now, in this context, kindly see, payment of fees for change in management. After getting approval of the state government or the excise commissioner, as the case may be, the collector shall allow change in management of a license after realizing 1.5 times the initial grant of fee to one applicable for a grant of new excise license of the same category of the same local area. The collector shall also record such change in concerned license. Then, my lord, the provision. Provided that no initial grant of fee or license shall be payable for a change in management in case of, my lord, these are the exceptions carved out. That there will be a change of management, but no fee will be payable. What? D is death of director of a private limited company. Well, I show the 2005 rules, which said death of director of a public and private limited company both. Death of any director. Well, death is inevitable.
Death is there in E also.
Correct.
Yes.
And my lord, kindly see E, death or change in management in usual course of business of a public limited company. So, my lord, in public limited company, one director dies, another director comes in. No fee is payable. Private limited company, the father dies, the son comes in, they will take it as that is what they have done. Here, my lord, that is what they have done. New Kenilworth has been, my lord, the company of Lordship seized, my lord, the shareholding as on 2018. And this remains unchanged as on today, 116. Look, this has been a company of the Bharats for the last 40 years. It's a heritage property. It has been of the Bharats for the last 40 years. Right. In fact, my lord, 116, this is as on 8th of March 2018. I show my lordship will find Raju Bharat, Managing Director. My lord, the license is in the name of the Managing Director. Then, my lord, all the shareholders, my lord, are of their sisters of Raju Bharat. BK Goswami, my lord, he is now more than 80 years. As per the Companies Act, my lord, you cross 70, you cannot act as a director. But I cannot remove him because the moment I do that and I tell again 1.5 times. And my lord, 5 bars, 1.5 times for each bar. That is the amount they have collected. And it was they did it just before Christmas, my lord. I was forced to pay and deposit the money. And till now, because of the pendency of the appeal, we have not got the refund. The order is to refund it. All are of the Bharats. And my lord, it is not their case that even one single share has gone to any outsider. And my lord,
You have
I
to
also
test the validity of the rules on the marginal propositions. I mean, not in your case only.
No, I am saying as a general, I am just indicating the factual background. Well, this is so far as 2018 is concerned. Now, will kindly see page 108. Because, my lord, this has a long checkered history. Initially, my lord, they raised a demand because, my lord, from a private limited company, I became a deemed public limited company.
Yes.
By operation of statute, because if your turnover increases to a certain thing, you become, because of the volume, my lord, deemed public limited. My lord, we challenge that. Then, my lord, that's it. That's an operation of law. It's not an act of parties. How can you foster liability? My lord, in the final order, which is after 3 rounds of litigation, collector admits that no, we are not doing it for change. Again, I become a private limited company. That is all right. But there has been change in director either for death or otherwise. Therefore, I will treat it as a change in management. Page 108, Lordship will find. Now, my lord, Lordship will get the position as on 2002. The chart is there. Page 108, Lordship will find MS Bharat was the director. And I showed the shareholding first. Now I am showing the director position. MS Bharat director, Lalta Bharat director, Raju Bharat director and licensee, RL Wadhwa independent director, BK Goswami independent director. MS Bharat expired on 26th of February 2003. Raju, Lalta, Wadhwa, Goswami, they were there. And because MS Bharat expired, Anjana Bharat comes in. So Kenilworth continues to be a company of the Bharats. And because of this, well, they treat it as a change in management. Just because board of directors, consequent of death, somebody new is coming of the family.
That was the question you were asking her.
Correct.
That even if a family member comes in,
Comes in. And now let us forget the factual aspect of this. Let us test it as a general proposition of law. Now, if I am recognizing that for a public limited company, if in usual course of business, Lordship asked a query. Now, usual course of business is not defined in Companies Act, nor have my lord the rules have indicated,
No.
but it is using the expression. Now, what was considered to be a usual course of business? Well, let us say a person in the board of director resigns, whatever may be the reason, either due to 284 or otherwise. To function, for a company to function, we must have an effective board of directors. This resignation has nothing to do with any change in shareholding or otherwise. Resigns, either the health is not permitting or there is a tiff with the management, whatever reason, he resigns. We just want to bring in another director in place and stay. For a private limited company, 1.5 times. For a public limited company, none. Or let us take the case of death. Simplicity at death, you don't add any director, you don't pay any fee. Law is the same for both public and private. In case of public limited company, all right, director has died, another director is appointed to take his place. Private limited company, even if the son comes in place of the father, 1.5 times. Change in management. This is, my lord, what it doesn't have a rationale or a reasonable criteria, my lord, for this discrimination. Up to, my lord, rule 2, you are treating both the private and the public limited company on the same path. Up to rule 2. Because any change in board of directors, I am to intimate, whether I don't dispute that. Because at every stage, the state is entitled to know which director is coming in, which shareholder is coming in. But there has to be a rationale. If a father dies, the son comes in, 1.5 times fee, because it will be treated as the old license has come to an end. On the contrary, my lord, what my learned friend stated, my lord, it should be the reverse. Because in a private limited company, my lord, it's operating on a much smaller scale. You should be encouraging the business rather than, my lord, putting a term. I can understand, my lord, under the garb of this, my lord, share transactions are taking place. Or, my lord,
even that would be valid for both public.
Correct. So, my lord, the reasonable criteria, I can understand.
So there is no intelligible difference.
No intelligible difference. Because, my lord, if death can affect the directors of both public and private, why can't the substitution be the same for both? Why should a private limited company be treated as if they are operating as a new license and 1.5 times because somebody else is coming in? Let's take another example. Independent director. In this case, Mr. Goswami is now over 80. I can't take anybody else. I will be again saddled with 1.5 times. Professional companies, independent director, nothing to do with family. In your professional capacity, board is required to have 2 independent directors.
Right? And suppose if it's usual course of business for both private and public, operate on the same footing. If usual course of business is the
correct.
indicator.
Let us take, my lord, Lordship knows that if you take, my lord, huge sums of, not a case here, but I am just trying to give instances of usual course of business. You take a huge sum of loan from any bank. Lord, one of the terms and conditions of sanction is that bank will have an independent director in the board to oversee that the money taken from the bank is utilized in a proper manner. So, in case of a public limited company, if a director comes in from the bank as an independent director or to oversee, it is in usual course, change in management.
And if you say in usual course, then that takes care of the whatever recollections you may have.
We are not asking for any special favor. If it is in usual course for public limited company, why will it not be in usual course for private limited company? This, my lord, there is no reasonable, no intelligible differentiation. And, my lord, the twin tests have not been there. And in this context, if Lordship analyzes the judgment, my lord, the learned judge has referred to the IFB judgment, which is also of the learned judge, my lord. in respect of corporate jurisprudence, what would amount to a change in management? Mere change in board of directors is not change in management. It is really because the directors are there. Every annual general meeting, it is at the pleasure of the shareholders, majority decision of the shareholders. So if the shareholders are there, the board will come and go, but the shareholders remain. That is really that is why Lordship will find a dead from Rule 2. The first expression which the legislature also has used is change of membership. It is not change in management. Just see sub-rule 2. And the learned judge has accepted the submission of mine. Sub-rule 2, once again, if Lordship sees, which is at page 1. One
62.
162, yes. A license granted under the Bengal Excise Act to a company, cooperative society or a firm shall stand determined on any change of membership of the company. So this is the primary test. Because for any change, when you are levying 1.5 times the rule, the rationale is that the old license is coming to an end. It is getting determined. And when does it get determined? When there is a change in the membership of the company. Then also for company, kindly see, unless prior approval of the state government in case of so and so. But if you obtain it, all the criteria is the government will have to be satisfied that it is in usual course. It's not really a transfer. If the government is satisfied there is no element of transfer, there is no change in management. And that is why now Lordship will see the 2005 rules. Page 168. Sorry.
164. No.
166 it starts. Kindly see what was there in 2005. This was, it appears to me, it was a inadvertent omission. But kindly see at page 168, the erstwhile, it was part of Rule 6. I read Rule 6, which starts at page 167. An application for change of name and style of an establishment having excise license shall be accompanied by so. That is Rule 5. Rule 6 is no initial grant fee of license shall be payable for a change in management in case of, kindly comes to clause 8. Death or retirement of a member or members or change of management in usual course of business of public or private limited company incorporated under the Companies Act. This is what was holding the field till 2005.
Might have been some expert in company law like me advised them.
No, it appears to be an inadvertent omission because I must be candid. It was going on, it is only after the deemed conversion from public to private, when they found that they are unable to sustain that case, they resorted to this. But this is the anomalous situation. And then after the writ petition is filed, to cover this up, they come up with a notification at page 164. This also can't have a retrospective effect, and the submissions were negative. Kindly see, this is very, because they try to take shelter that substitution in a definition will relate back from the date of that. But I indicated that law is only applicable if the definition originally existed and you are clarifying what you meant. But you can't bring in a new definition and then say it is having that, because it amounts to giving retrospective effects. You can't indirectly do what you directly cannot. Now in 164, on 11 February 2020,
there was no definition of change of management.
No.
Then it cannot be clarified. What do you clarify? It was not there.
This is for the first time. Change in management is thought to be defined. And that is what has been noted by the learned. And over here, change in management means, kindly see C and D. In case of a private limited company, when there is any change of directors or change of shareholding amongst the shareholders beyond 10% of the existing shareholding pattern. So, but even let us test it over here. Where is the question of change in shareholding? But change in directors per se, change in management for a private limited company. And then for a public limited company, change in directorship other than appointment or cessation of independent directors within the meaning of 149 or any change in shareholding. Now, change in shareholding beyond 10% is now made the same for both.
Both are made the same for change in directorship and only cessation of independent directors that's applicable to
Correct.
private limited,
Correct.
public limited.
So here, my lord, I can understand that what is, my lord, again the test is for an intelligible differential is that the purpose of the rule is to ensure.
Now this rule is applicable, new rule is applicable. If you you win, you get a refund of the amount charged.
I am restricting my case, my lord, vis-a-vis the old portion.
During that period when that
because,
was
my lord,
the refund.
The impact of this we have, because there was no scope to go into this, because my lord, this they put it by way of a supplementary after the writ was concerned. We did not challenge the virus of the new notification as and when if they try to implement.
So you are confined to the
we are
amount you have been charged under the.
We are confined because, my lord, this is the period when, my lord, this Kenilworth Hotel has 5 bars run. So for 5 bars, there are 5 separate licenses because everywhere it is on your physical location of the bar.
1.5
times, and my lord, the demand was made just prior to the Christmas
How do you refuse somebody?
But we were unable to get an interim order. We had to secure the entire money. And then, my lord, lordship will see there is a long history of, my lord, orders passed. It went back and forth from the collector, appellate authority, this and that. And finally, my lord, this has taken place where our objections have been upheld. This portion, my lord, one unique feature of this, my lord, lordship has seen, my lord, reading down of a statute. Here the reverse principle has been applied, that it is otherwise ultra virus, but if you want to implement it in usual course of business has to be read up. The statute has to be read up accordingly. That, my lord, that principle the learned judge has accepted our submission to that.
No,
and, my lord,
usual course of business has to be read up into D.
That if there is a death and there is a change in management,
there is no scope left for reading up also.
But then, my lord, then the entire provision.
Because if there was some scope in the language,
otherwise, my lord,
not there. Just
otherwise, then, my lord, entire thing would be declared ultra virus, and the 2005 rule should come. 2005.
It has been read up.
It has been that you have to read it because.
But you cannot read usual course of business.
So that is the alternative, my lord. That is what has been.
Because otherwise, we have to read usual course of business into death.
No, usual course of business can only come for vis-a-vis changing management.
Changes management is not there in the at all. That's what we're saying. You cannot. There is no scope of reading up also.
No, if lordship declares both as ultra virus, then the earlier rule will be because it can't be.
And that is not reading. That is. Very. He also.
This is the idea is, our endeavor is not that the state should be deprived of revenue. If there is, today, if the Bharats try to change the ownership of the hotel to somebody else, but obviously the state is entitled to revenue.
But direct, your direct remedy would not help you. I mean, if D is struck out, then you don't have death also.
It has to be, entirety so far as this is.
Actually, you should have challenged E. Virus of E.
No, my grievance is vis-a-vis a private limited company.
No, E in the sense that E cannot remain. I mean, very well. We'll read the challenge to be a challenge to E and E as cumulative challenge.
That discrimination that I am complaining of,
right,
is that death is affecting equally both a private limited and a public limited company. If a director is coming in usual course because of death or any other vacancy, I read 284, my lordship will see, any other vacancy. Somebody is unwell, the board of directors is unwell. He says, I can't continue. Please appoint a younger blood in my place. In case of public limited company, it will be a usual course. In case of private limited, it will be 1.5 times.
They will be harping on the additional grounds that you can put in for a private limited in 283.
No, I can.
3,
Because
23,
that
3.
is why Lordship will find the rules are very clear. Both public limited and private limited will have to inform the authority, the state, in case collector or that, even if one shareholding is changing, either transmission or transfer, even if one director is getting replaced for whatever reason, so that whether the authorities are in the loop that what is happening over there. And nowadays, post the Birla litigation, Lordship, a lot of talk of what is known as the controlling interest. So even with 1% transfer of a shareholding, there can be a shift in controlling interest. Let us say a company has two equal shareholders, 50% and 50%.
Then 1% may create it.
1% goes. On pen and paper, it will appear only 1%, but controlling interest is getting transferred. So even with 1%, because the small minority who comes in, they will. That is why the government has ensured, or the legislature has ensured, that the government is kept in the loop of whatever minor alterations happen, both in case of a public limited company and a private limited company. So up to rule 2, you are treating both a private and a public company at par. Now what suddenly happens in rule 5 that you are making this distinction? Why in usual course of business if there is a change, that I will be saddled with 1.5 times. There is no intelligible difference. And this is exactly what the learned judges held. That difference in law vis-a-vis public limited and private limited has no application, because even till rule 2 you have treated them at par. So why are you making this departure in rule 5 that for usual course they will not have to do? Well, kindly see paragraph 49 of the impugned judgment at page 266. Internal page 25. If Lordship reads from the memorandum of appeal, it's internal page 25. But in fact, if I may just read from internal page 24, after the arguments are quoted, in the middle the quote. The 2009 rules do not differentiate between a public limited company and a private limited company. As stated above, the word company appears in several places, or to be more precise, in Rule 4.2, where the provisions have been equally applied to both public and private limited companies. This is also clarified in the second paragraph of Rule 4, which expressly refers to any change in board of directors of the company, both private limited company or public limited company. Therefore, Rule 5 cannot carve separate conditions out in clauses D and E applicable to a private and public limited company respectively. The test is whether intelligible differentia exists for making separate provisions for public limited companies and private limited companies in the context of 2009 rules, and more specifically for payment of license fee under Rule 5.1 thereto. The provision of the Companies Act 2013 or its predecessor statutes are not relevant for satisfaction of the test of intelligible differentia in interpreting the 2009 rules, since the differentia must also have a rational connection to the object of the 2009 rules. This aspect has already been dealt with in the earlier section of this judgment and is not being repeated. The Companies Act discloses intelligible differentia for making separate provisions for public and private limited companies. The definition given to private and public companies in sections 268 and 71 of 2013 would show the differentia between the two relate to restriction on the right of transfer, limiting the number of members, and prohibition from invitation to public for subscription of securities. Unlike the Companies Act 2013, Rule 4.2 of 2009 rules does not make any distinction between a private limited company and a public limited company in the matter of determination of license. Hence, the departure from the generality of import of the expression company used in Rule 2 becomes even more pronounced when a public limited and private limited company are treated as two separate groups only for the purpose of exemption for payment of license. So this has been the rationale that the object is under what situation license fee will be payable and what situation it will be not.
Apparently, the idea was that being private limited company, you can have additional grounds than enumerated in 283, and you can carve out certain things to evade. But
Let us
usual course of business still remains.
let us fix the position. What is falling from here?
What would be the best case for them? We were wondering that.
No,
That what rule could you carve out
let us say, my lord,
to wriggle out of this?
let us say, my lord, a private limited company in its articles of association has
Yes.
an article that they can bring in outsiders
Yes.
who will run a company. Because my lord, so far as removal is concerned, it is there. There is no restriction. That
But a public limited company can do
can
that.
also do that. Now,
If
my
there
lord,
was a special exemption given to
Correct.
private limited,
Correct.
then
So,
we
my
could have
lord,
understood.
my lord, on the contrary, lordship goes that a private limited
More
company,
restricted.
the restriction on share transfer is it has to be within the family. That is what the article says.
Precisely, yes. So
And
you have
that-
lesser scope of this.
Correct. In fact,
bringing it outside.
in public limited company, shares are freely transferable.
Hmm.
So, my lord, in these cases where you are holding a license, excise license, one transfer of share, my lord, law assumes that the original license is coming to an end. That is how Rule 2
Yes,
starts.
yes.
Cessation of the license. When there is any change in membership, and membership is equivalent to shareholding, there is no other. So here the case is peculiar. Now, even in case of shareholding, my lord, that is IFB case of shareholding, kindly visualize, my lord, a transmission of shares cannot be equated at par with transfer of shares. Father dies, share comes transmitted to the son. There is technically change in membership to the extent of the transmitted shares. But that will not amount to change in management. That was clarified in the IFB one. Here, my lord, this is the virus was challenged because of this and this was clarified. So, my lord, with respect, my lord, I don't find there can be any illegality. And my lord, the test of, my lord, what should be an intelligible differential, my lord, the case cited. The case cited, my lord, the twin test we have shown, my lord. Kindly see the twin test that has been quoted, my lord. After if they indicate anything to the contrary, my lord, I will show that. Because, my lord, Budhan Chaudhuri's case was cited, my lord, and it has been referred to. Paragraph 5, my lord, in fact, on the judgment I just show. Judgment is pure order. But now the Advocate General is here, we can have the benefit
Of his doubts. Yes, sir.
One paragraph on facts.
Yes.
If my lord may kindly have a look through page number 38.
Paragraph.
Page 38, paragraph 49.
As internal page 30.
Internal page 28,
No.
running page.
Of what? You are placing what?
No.
Okay. Volume 1, page
38.
30. Yes. This was the writ petition.
Part of the regulation. When I speak over very paragraph 49, the petitioner states that the petitioner for one company at all material times was and still continues to be a company controlled and owned by others. And induction of new directors have already taken place in the usual course of business by reason of existing directors being incapacitated on account of illness and old age and ultimately on account of their death and or otherwise effectively and efficiently carry on business of the company in its usual course. The same does not and cannot constitute any actual change in management. In this context, the list of directors first.
Then we will dates we get in at paragraph 50. The petitioner states that it would appear from the said list that prior to 27th December 2002, MS Bharat, who was already a senior citizen, was diagnosed with terminal illness and was unable to effectively discharge his functions as a director and ultimately expired on 26th of February 2003. In the background of the terminal illness of MS Bharat, Mrs. Anjana Bhagat was inducted on 27th of December 2002. Such induction of Mrs. Bharat on account of illness of Mr. Bharat was further vindicated and justified by the fact that MS Bharat expired on 26th of December 2003. Similarly, by reason of old age and consequential illness resulting therefore, Mrs. Lalta Bhagat in the year 2009 was unable to
Sir, Dr. need not read all these similar.
yes, or in other,
Terminal illness, age.
or in other words, change first, death later.
No, change due to terminal illness.
Yes.
He was unable.
Yes.
And death later. Did not have to die to.
Yes. So it's not that in the ordinary course, because of the death, someone was replaced.
All
It
right.
is the other way around. Maybe I don't
Understood.
dispute that. So the change of directorship
Yes.
takes place first and then you have the death of that person. So in this background, we need to consider not the rules but the facts of this case. Now, insofar as the rules are concerned, first, as I had indicated on the last occasion, that a license or an excise license is a privilege. We do not have a right to carry on business in liquor. Therefore, the entire rules or the judgment has to be construed in the context of the width of the rights.
You say Article 14 is not available in full rigor.
Yes.
In a privilege.
Yes.
So it's a privilege.
All privileges come with conditions.
But the conditions have to be equal for all.
Yes.
Particularly since you are the state.
Let us presume that Article 14 will apply in its full vigor.
Yes.
Let us presume that. Then also, there can be reasonable classification.
Definitely.
There can also be preferential. Article 14 permits preferential
treatment, but that also has to be on the criteria of reasonable classification.
Yes, definitely.
Definitely preferential, reasonable classification, in other words, is preferential treatment for some class. But it has to be reasonable. And has to have a proximity with the purpose sought to be achieved.
Reasonable classification, as I understand, two groups of people are put in two compartments, and one compartment is favored, the other compartment is not favored. That is a reasonable classification. To disfavor a body of course.
But then they have to stand on different footings, don't they?
Yes.
If they stand on similar footing, we cannot put them into compartments.
If they stand on similar footing, then there can be a preferential.
Okay. Very well.
Like in our service jurisprudence, I offer or I initiate a recruitment process. I fix the eligibility criteria. And then I give a preferential treatment, saying that for 5 posts, 5,000 people have applied. I am not going to consider everybody. I consider only those who have, let's say, 75% marks in the board examination.
Subsequent to the recruitment process.
Subsequent to the.
All right.
Though there is no rule, this play in the joints is there. What I do is, I give preference to A class, thereby will not taking away the right of consideration of the others who do not fall within that category or class. So this is permissible.
But doesn't it have to have a nexus with the purpose sought to be achieved? I mean, you are recruiting, say, sports person, and you discriminate them on the ground of, say, some absolutely unrelated criteria, how they look.
Yes, I understand, not at the ranks.
Has to have a connection to the partner for which you're recruiting. You seek, you recruit sports persons, and you say, I put a cutoff at 30 seconds for a particular distance. That we can understand, but you can't say we'll select the fairer people and not the
Right.
darker people.
Right.
You cannot say that, or vice versa.
Right. It must have a
Connection,
Right.
nexus with the purpose for doing.
Provided, my lord, your lordships are of the view that Article 14 has its full application.
You're giving a license to whoever you like, Mr. Dattu.
No, it's not a question of
Preference we can understand.
Yes. It's only, my lord,
You're the state. I mean,
but after all, my lord, it's a fiscal sector. End of the
Yes.
day, it's a fiscal sector.
yes.
Number one. Number two is only granting of a privilege at a cost, at a price.
At different prices for different people.
Can,
That is what. Yes.
can. This has always happened. In all fiscal statutes, this has happened. Say, though it's a direct tax aspect, take an example, the slabs that we have in income tax.
Yes, understood. That is a part of the state policy, that richer people would be taxed more, or
Yes.
those who earn more.
Right.
That we can understand. But then there is an excess with the purpose of to be achieved. Because those people are earning more, you are taking up you are fixing a higher percentile to distribute it equally in a welfare economy or whatever. That we can understand. But if they stand on otherwise equal footing, both are companies. Private public don't have any distinction regarding usual course of business changes. Then how can you pick and choose between them? That you have to, I mean,
Yes, private and public company, in my, again, my,
and as per up to your rule 4,
yes,
they have been kept on same footing. They have to obtain permission equally, approval or permission, prior intimation equally, their licenses equally lapse on change of management. But suddenly you give a particular preference to public limited companies, or rather withhold those privileges from the this private limited companies.
yes.
You have to have a basis for that.
Then I'll explain my own view. Now, first, so far as the judgment is concerned, my first respectful submission would be
Yes.
the judgment proceeds on the basis that it is a crystallized right between two parties upon privilege being granted. Therefore, the strict rigors of intelligible differential with rational nexus is to be applied. Please test this whether or not the same principle would apply in a case of a privilege.
All right. Very well.
Now, once a license is granted, what is the right? Well, the right is to carry on business uninterruptedly, provided the disqualifications are not incurred and provided with whatever are the obligations like payment of fees, renewal, XYZ, these are done. This is the right which accrues on grant of a license. Number two is post license also, there is regulation by the license granting authority.
Yes.
Which is sometimes quasi disciplinary in nature as well, like suspension.
Penal. Yes.
Now, please take note the issues which the learned judge formulates at the seventh page of the judgment, running page 240. The controversy is presented to the court on two plans. The first is whether the death of a director and consequent appointment of another director to the board would amount to a change in the management under the special rule. The pausing here for a moment, Millar. The formulation of this question is contrary to the paragraph in the writ petition which I had placed.
But they're challenging the virus also.
Yes, I'll come to that.
That's in their particular case. But this is more general because they are challenging the virus. This had to be framed. Otherwise,
No, it says that
Acha,
consequent appointment,
consequent appointment.
death consequent appointment.
Already.
The second issue is whether clause D to the proviso to Rule 5 of so and so is discriminatory and offend the right of the petitioner to equal treatment under Article 4. But I skip over here paragraph 14 and 15. Then after paragraph 15, there is a heading, changes in the board of directors in the usual course of business does not amount to change in management. The issue arises from the interim order of 16th February, whereby the Excise Commissioner found that changes in the petitioner's board of directors in the usual course of business would attract levy of new license fees and would not be covered within the exception carved out under the proviso to 5(1) of Rule 2009. So in other words, the Excise Commissioner was of the view that the petitioner number 1 being a private limited company would be held captive under clause D to the proviso of Rule 5(1), which exempts payment of initial grant fee only upon death of a director of a private limited company. The issue where the changes in the board of directors of a company would entitle levy of 1.5 times of the initial grant fee under Rule 5(1) was considered in RFP. The facts before the court in that case involved appointment, resignation, expiry of terms, and death of directors of petitioner and other facts, such as these would amount to change in management at the court. The petitioner in that case was a public limited company as opposed to the petitioner number 1 being a private limited company in the present case, which was relieved by levy of 1.5 times initial grant fee similar to the one applicable for grant of a new license. The court held that a change in management in ordinary parlance as well as in company law would be a change in the shareholding pattern of a company with an implication on the voting rights of the members and shareholders of a company. This court relied upon voting, which defined controlling interest as vesting in the voting powers of a company's shareholders and ascertaining who controls the affairs of the company. Even if the decision in RFP is kept aside, the change in management necessarily implies a movement of a body of shares with a consequent change in the shareholding pattern of the company concerned and a change in the exercise of the power and control of the company. Appointments to the board of directors would not have any impact on the shareholding pattern of a company so as to impact the controlling hands there. This would be evident from Rule 4.2, which mentions inter alia change in the membership of the company and continues the implication of the first proviso to Rule 4.2, where change in management has been equated with change in the form and structure of a company, for instance, or from a private limited company to a public limited company, and vice versa, or in case where there has been a takeover or acquisition or amalgamation or merger of a private or public limited company, so change. Apart from this, Rule 4.3 mentions the word proposed transfer. Read together, only possible conclusion would be that change in management would be a change in the fundamental structure and controlling ownership pattern of the company. The change must be in the formation of or creation of the new company, transferring its ownership, its command, and structure, shareholding, composition, rights, and voting rights. Therefore, appointment to the board of directors can by no means be equated with a change in the management. We are pausing here for a moment. My learned friend has made a submission that the subsequent change in the rules defining change of management cannot be clarificatory in nature and cannot have a retrospective. But I'll make my submission on that. If a phrase or a word is there in a statute which remains unexplained or there is some ambiguity to it.
So you say although there was no definition of change of management, that expression was used. So you clarify that.
So it gets a retrospective effect. Well, otherwise, as your lordships are held, that judgments are always retrospective. Legislations are already prospective.
By default.
Unless,
by default. Yes.
yes.
Unless
specifically provided or provided by law. The exception to that is clarificatory legislations. Clarificatory legislations go back to the inception.
That was it. What is the date of the subsequent
2020?
2020?
I will give you the date. It's 11 February 2020.
Right. But even as for that, the public and private limited companies are put on a similar footing.
More or less.
More or less. So how can you derive benefit from that insofar as the present challenge is concerned?
Because the Russian kindly have a look at your once exact page 164. The first part covers any change of directors.
Yes.
We need not go into the change of
Independent directors is different in public limited company, which is quite obvious.
Yes.
But the rest is exactly the same.
Yes, in case, but so far as the portion which is attracted in our case on the anvil of so-called discrimination.
No, if the change of management is the same for both,
yes,
then all the more it's discriminatory. I mean, how can you discriminate between the two?
Well, may I say this?
How can you give an exemption to one and not to the other?
Because I think that there is no exemption so far as public limited company is concerned in respect of change of directorship, at least. Well, we are with a case before your lordship when there has been a change of directorship.
In the impugned these provisions,
Yes.
death of director is common for both, only given to private. And in addition, public limited has change in management in the usual course of business. So if change of management is defined as the same for both in your clarificatory regulation, then Mr. Datta, then I mean, this exemption should also be same.
Could I say this in a humble way?
Yes.
But ours is a case where I have charged them 1.5 times. Why? Because there has been a change of directorship.
They say in usual course.
They say in
one died, they put
that will not should be decide whether it is in usual course or not. Now on the Article 14 aspect, change of directorship, where the definition of change of management is the same for both.
Exactly, yes. Then why should one get benefit and not the other?
Yes. That is on the fee charging part.
For change of management. Fee charging is for the change of management.
Right.
If change of management is same for both, one gets usual course of business change of management as an exemption,
right.
The other
doesn't get.
Yes.
This is where I need to address your lordship on the reasonable classification. Reasonable classification is also part of Article 14. It is not beyond Article 14.
I mean, if it's clarificatory, it goes against you in a sense.
Yes. Primarily, you know, the.
Apparently, it goes against you.
Primarily,
Subject to what you say.
provided I can satisfy your lordship that putting the public limited company
Otherwise, yes.
in a separate compartment amounts to a reasonable cancellation. Now we're coming back to the judgment. Please come back to the page 251.
Yes.
Although, paraphrase,
Yes.
although not relevant for the present proceeding, the finance department of the government of West Bengal appears to have become wiser. The implications of change in management, which would be reflected in the notification of so and so. Rule 31C defines senior management service. In conclusion, appointment of new director either by reason of death or death of an existing director or in the usual course of business without any impact to the shareholding pattern or membership of the company does not amount to any change in management since there is no transfer or movement of shares in the company. Induction of a new director into the board would also not fall within the meaning of the expression transferring. In other words, a change of management of a company should be of a nature so as to determine the ordinary excise license in terms of Rule 42 and result in a proposed transferring in terms of 43. The usual fitness and eligibility criteria for holding an excise license would come with considerations only after there is a structural change in the company. The classification made under clause D and E of the proviso to Rule 5.1 is not founded on intellectual differential and does not have a rational nexus to the object of the 2009 rules. The second plank of the petitioner's argument is mounted on clause D of the proviso to Rule 5.1 of the change in management rules clause in controversy together with the relevant part is set out. When I skip over the set out, then the charge of discrimination would be better understood if D is contrasted with E, whereas your lordship said
Yes.
if D and E are read in the context of Rule 5.1 and proviso that the construction would inevitably be the requirement of the payment of 1.5 times the initial grant fee, similar to the fee applicable for grant of a new excise license for the collector to permit change in management of a license. Change in management of a license would not be applicable in the case of death of director for a private limited company and death of director plus change in management in the usual course of business of a public limited company. The disparity in the applicability of the proviso to Rule 5.1 namely exemption from payment of 1.5 times the initial grant fee of license for a public limited company compared to a private limited company would thus be apparent from clauses C and D respectively in the proviso to Rule 5.1 itself. To hammer the disparity home, the exemption from payment of license fee pursuant to a change in management is much broader in case of a public limited company where, apart from death of a director, any change in management in the usual course of business would also entitle the public limited company for exemption. A private limited company, however, would get the benefit of exemption only upon death of a director and nothing more. Private limited companies have thus been left out of the purview of the change in management in the usual course of business. Therefore, increasing the zone of exemption all public limited companies from payment of license fee under the proviso to Rule 5.1 no doubt sets the ground for unequal treatment in the matter of payment of license fees for the changing management. The inequality must, however, be tested on whether the classification of private limited company and public limited company in clauses D and E respectively satisfy the free test of being founded on an intelligible differential and the differential having rational nexus to the object sought to be achieved by the 2009. The disparity which is apparent in clause D and E of proviso to rule 5.1 is one which also does not find any front end support from the preceding part of the rule. This view would be buttressed by the following. Rule 4 of 2009 rules does not envisage a separate procedure for public and private limited companies. Rule 4.2 repeats the expression company in several places without any distinction being made between the private and public. The second paragraph of Rule 4.2 significantly clarifies any change in management in a company or any change in the board of directors of the company, both private limited or public, both private limited company or public limited company. Rule 4.3 authorizes the collector to inquire into whether the proposed transferee are liable to hold an excise license. The test of fitness and eligibility of the proposed transferee is not made either with reference, not made with reference to either a public limited or a private limited company, and must hence revert to the second paragraph of Rule 4, which specifies both private limited company or public limited company. Hence, carving separate provisions out for the first time in Rule 5.1 and the proviso thereto is unreasonable and without support of the rules. There is also no rationale disclosed for making two separate groups from the hitherto general head of the company in clause D and E of the proviso to 5.1. The offending proviso has carved out different provisions for levy of fees and exemption for payment of fees pursuant to change in management for private and public limited companies, creating two distinct groups and bestowing a larger zone of exemption for one of the two groups must be supported by intelligible differentia in the creation of the two groups. The 2009 rules does not satisfy this test. What is intelligible differentia? Article 14 of the Constitution of India guarantees to all persons equality before law and equal protection of the laws within the territory of India. To translate this vision into meaningful action, the state is authorized to create groups or classes for grant of certain benefits or exclude certain persons from those benefits. Article 14 of the Constitution is not violated by creation of classes based on rational differences, since the state can step in through affirmative measures in aid of constitutional goal of equality. However, the requirement which must be fulfilled is of shared characteristics of persons within a group which justifies their being grouped together, as opposed to those. Yeah, what page 50?
Next page. Next page. Please go to the next page. We have already been there.
Those who are outside the group. The distinction between those inside and those outside must be intelligible. That is, be measurable by reasonable parameters. The persons who have been excluded from the group must understand that they have been left outside the group in view of not possessing those defining features. The test of intelligible differentia is vital to the constitutional charter of equality in competing groups. It is antithetical to equality. The distinguishing markers in the differentiator which justifies classification without those markers, which is of utmost importance, that groups or classifications promote equality by way of intervention and do not undermine the same. The state's power to take the vision of Article 14 forward cannot be done to random classification where persons inside the class do not have homogeneous or defining features which distinguishes them from those who are outside.
Mr. Duffy, if you want to read, you can read, but you have read up to para 36.
Well,
So the principles.
yes. Now the rational nexus object.
That also we have seen. Yes, it's obvious. Yes.
Yes. Then please, the
37. These
70, your lordship has skip over paragraph. I am sorry, page 17. Kindly now come to the final findings below paragraph 41.
Yes.
But after concluding that there is no intelligible differentiation, this is the
Yes.
finding. Apart from the absence of any intelligible differential in the classification, by no stretch of imagination can it be said that the appointments of new directors in the usual course of business or for filling up a vacancy caused by death of a director in a private limited company is equal to a proposed transfer for grant of a new license of the same category under Rule 51 of the 2009. The larger zone of exemption for a public limited company from payment of license fee pursuant to change of management should have had a comprehensible connection with the object of the 2009 rules in terms of determination of the earlier excise license and grant of a new excise license to the proposed transfer. The disparity in the scope of exemption for a private and a public limited company, or in other words, reducing the area of exemption for a private limited company, does not preserve the object of the 2009 rules. The link between the classification created by clauses D, E, and proviso thus snaps and is broken in attempt to connect it to the object of the rules. Therefore, the differential made for classifying private and public limited companies under two separate groups under clauses D and E of the proviso to Rule 51 does not have any intelligible basis. The differential for the classification do not also have a rational nexus to the object of the rules. Then Article 14, I will not trouble you with that because that may not be required. Please take me at internal page 21. Top. Absence of intelligible differential and the rational nexus to the object of the 2019 rules impacts the constitutional validity of clause D of proviso to Bill 51. Without repeating the discussions in the earlier section of this judgment, the inevitable conclusion must be that clause D of proviso to Rule 51 of the 2009 rules offends Article 14 of the Constitution in terms of treatment of a private limited company when compared to the right conferred to public limited company. The petitioners have made out a case for a declaration that clause D of proviso is ultimately so and so. The response to the respondent's argument, it is not requirement I can read this, but
No, I don't understand why Mr. Chaudhary also argued that it is not clarificatory, it does not relate back, and you also argued the reverse, and the court also, because in our view, I mean, subject to correction by both of you, I mean, if it's clarificatory, it helps Mr. Chaudhary in the sense that by virtue of this subsequent 2020 thing, you have not, I mean, removed the disparity complained of. So rather, you highlight that by equating them on the footing of management, but giving exemption to one. So it goes in favor of Mr. Chaudhary's client in a sense because we are making it clear to you. Because management, now you have change of management you have defined. They're on similar footing. But you give exemption to one person.
Right.
That is where we are.
Yes.
So it goes against you in a sense.
But the crux of the issue is exemption.
We accept your contention that it's clarificatory.
Yes.
And refute his contention that it's not clarificatory.
Right.
But then it helps him.
But today we are poised with two basic assets of a dispute.
And in intracourt appeal, Mr. Doctor, sufficient reasons have been given, concepts have been clarified.
I tell you, Lordship, why will this your Lordship intervention is required? Today, Millard, we are primarily, if I put it in a small compass, it is a case of exemption being granted to a group or a class and exemption not granted.
Yes.
Way a privilege. And in order to champion the case of the petitioners challenge a rule which is under challenge over here is a subordinate legislation. It definitely does not have the immunity, prima facie immunity that of a parent law or a statute, but it has got some elements of validity, unless proved otherwise. Where their lordship have confined the grounds for challenge of a subordinate legislation to few things, which are number one is whether I have the legislative power. Where there is no question of any lack of legislative power. Where number two is whether is affecting any constitutional rights. Number three is whether it affects a fundamental right or not. Well, whatever is the nature of the right, over here, the right is to carry on business
19 and 14 articles.
and whether it is arbitrary. Now, this arbitrariness is not the arbitrariness as we understand within the widest scope of Article 14. But it says that arbitrary in the sense that the legislature does not confer power to this subordinate legislator to frame such a rule or a guideline or a what should I say provision.
But discrimination, Mr.
Yes.
Also violates a fundamental right, equality,
Now,
and right to do business in a sense.
how is it discriminatory according to that? That you are giving exemption to him, you are not giving exemption to me. Please consider whether this can be considered to be a discrimination, because granting of exemption is completely without my priority. But in various statutes, your lordship will find towards the end there are exemption provisions, and all these exemption provisions, your lordship would find, my lord, is at the discretion of the authorities. For example, if your lordship takes the Provident Fund, towards the end, your lordship would find, my lord will find that there are exemption provisions. Now, wherever there is exemption, my lord, it is always, my lord, at the discretion of the authority granting exemption, number one. Number two is this exemption can differ from applicant to applicant. Again, at the complete, my lord, discretion of the what do you call that, authority.
No, but that element of discretion has to be there in the parent statute.
Yes. Yes.
So here it's a statutory force thing we are talking about.
We are putting treating it as a.
So this is a sort of taxing statute.
Yes.
In a delegated legislation sense.
Yes.
Because you're imposing revenue, I mean taxes. Very well.
So therefore, my lord, what is primarily to be looked into?
So you are seeking statutory immunity as opposed to executive action.
Yes. But I am not discriminating between black and white.
That you could discriminate.
No, in a case like this.
not in the context of human color, skin color, but otherwise black and white has to be discriminated. No, they try to paint it black, but you're trying to, which is also discriminatory, that usage. So therefore, statutory immunity you are seeking in a sense. Because we have to be on a very higher ground on statutes than executive action, definitely.
So this is not absolutely not a discretionary jurisdiction. Where the concept of discrimination will not come, the concept of intelligible differential will not come, the concept of rational nexus to the object should to be achieved. But one point I forgot to tell you sir, on the ground of challenge, that is repugnancy also. Repugnancy means we are repugnant to the main statute.
Yes, that is also there.
There it is.
Up to 4 bits of a different. No front end support. That's the expression used.
Yes. Some of my judgments are not.
Great. We have 4 minutes left in India. Take it. Already. Yeah.
Next,
In the list, for a effectively next Thursday, we take up hardened part for further hearing. We are putting it on next week. For further hearing, list the matter on January 22, 2026.
Before my lord rises, item number 9 and 10, my lord, it will again spill over to next Thursday, my lord. I was thinking even can be on 29. On 25, I have personal difficulty. Next, item number 9 and 10. Instead of
29th is the next Thursday. Next Thursday is 29.
Next Thursday is 22nd.
22nd, yes.
Instead of 22nd, I was just missing it can be on 20.
Who was arguing? You were arguing? Or
We haven't even initiated our argument.
you are the respondent.
I'm the respondent.
If you are in difficulty, ask any of your friends to.
If my lord can be. So that we don't waste my lord's time.
Yes, but it's 29th তাহলে bracketed item
9 and 10. 9 and 10.
9 and 10 9 and 10 টা ব্র্যাকেটে করে রাখুন ইয়ে একটা অর্ডার লিখুন at the time of rising comma the matters are mentioned by learned counsel for the respondent who seeks an adjournment till January 29, 2026. So to stop next para, accordingly let the matters stand adjourned till January 29, 2026.
Grateful. Well, that's what troubling you.
No, the troubling your learned friend because he's the appeal and he was
The lordship,
disturbed.
I have a similar claim on 22nd, my lord, I'm not there. Item number 13, my lord, I appear for the respondent.
Your other side is not there.
My lord,
You keep some of your keep any of your friends ask and intimate your other side.
I in advance, sir.
Here both sides were there.
Yes,
That's why
I will,
And I have intimated him in advance.
I will intimate.
you get a clue from that.